Welcome to the August 30th, 2022 Zoning Board of Appeals meeting for the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do roll call. David Murch.
Fred Miller. Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes of the July 26, 2022 meeting. Old business, ratification of findings of fact specific to the administrative appeal. Read notice of violation issued 1/4/2022 via B. Ratchin Esquire on behalf of Q Teams Inc. And the following public hearings on the following matters. Administrative appeal, read notice of violation issued 12/21/2021, Duran Excavating. And we have administrative appeal, read notice of violation issued 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine LLC. Then this next one is actually number 4 on the list, but we'll be bringing it up. Administrative appeal, read notice of violation issued 1/28/2022, Duran Excavating, specific to 28 Whitetail Lane. Then we have administrative appeal, read notice of violation issued 1/28/2022, B. Ratchin on behalf of Management Controls for 28 Whitetail Lane. And we have administrative appeal, read notice of violation issued 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine, location 28 Whitetail Lane. And we have new business, administrative appeal, read denied business license, applicant Adam Nappy, High Wire Hydroponics. Then we have code enforcement officer communications, and then finally adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and their affiliation with the application, being it for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board is formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So, Fred, Pete, assuming that you received the meeting minutes from Sandy, did you have anything to discuss with regards to those?
I do.
Okay, so I'll take a motion to approve those minutes from the July 26, 2022 meeting.
I'll second that.
I was going to take a motion, so I need someone to actually make the motion.
I motion that we accept the minutes from the last meeting.
I'll go ahead and second that. Okay. So any further discussion? All those in favor of accepting the minutes, we have to do a roll call vote. So David Murch, yes.
Fred Miller, yes.
Pete Lockwood, yes.
All right, very good. So moving on to old business, ratification of findings of fact. For administrative appeal, notice of violation issued 1/4/2022, applicant Leah B. Roshan Esquire on behalf of Q Team Inc., location 18th Wood Road. This is something that got put on the table at the last meeting, so I need somebody to make a motion to take it off of the table.
David, can I just have a point of clarification on the procedure? Just
Of course, yeah.
Business, yep. So I think I just want to clarify because I think there's a little bit of a discrepancy I'm seeing now between the agenda and what I advised council of in terms of what we'd be covering today.
Okay.
Old business. So just to confirm, my understanding is we'll start as it is with finalizing the decision for the Q Team Fernwood appeal, and I've circulated a draft decision for that. Then we'll proceed to continuing the public hearing and deliberations on the Duran Excavating Fernwood appeal. Then we would also cover the Big Lake Marine Fernwood appeal, and then we would address the timing issue only of the Duran Whitetail appeal.
Correct. That matches this board's expectation. Does that match our other participants' expectations as well? Greg?
I point out that the appeal for the Duran excavation for 18 Fernwood Road and the appeal application for the 28 Whitetail Lane are essentially combined in the same document, and they are initially, going to be decided on the exact same issue, which is this idea of timeliness. And so I think, rather than make those arguments twice, it makes sense to just take up what I see as the first new business item and fourth new business item together, especially since we're only going to address timeliness as it relates to the Duran Excavating 28 Whitetail Lane application. Take those two up concurrently to start, and then address the Big Lake Marine LLC 18 Fernwood Road.
Seems to make sense to me. Stephen?
Yeah, I think it makes sense, and I think that as the appellant has the burden, they can set up the appeal as they'd like.
Okay, we'll do that. So, I forget, we took this off the table, didn't we? Did we go through that vote? We haven't taken it off the table yet?
No.
Okay. Okay, so did we at least make a motion and second it? I kind of forget.
I'll take a motion to take it off the table.
And I will second that. So any further discussion before we make a vote? David Murch voting yes to take it off the table.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. So Stephen, I don't know if you want to sort of guide us through this process when we received the documents
Sure.
earlier today.
Yep. So where we are procedurally is that we've held the public hearing on the 18 Fernwood Q Team appeal, and the board closed that public hearing and closed the record, and then entered into deliberations on that. And we made what the board characterized as preliminary findings of fact and conclusions, and took votes on those for a total of 4 issues on appeal. And then we continued those deliberations with instructions for me to prepare a draft written decision that reflects those facts and conclusions of law. And so I apologize for how close to the hour I submitted the written decision to everyone. I will endeavor to do much better with my timing moving forward. But can I confirm that the board members have received the written decision of the Administrative Appeal of Q Team Inc. January 4th, 2022 notice of violation?
I did receive it, yes.
Okay. Had a chance to review it, I can go over just a high level what it says.
I did have a chance to review it personally, yeah, but a high level review would be appreciated.
Sure. So it follows the same format of the board's prior decisions, concludes that the appellant has standing, it was timely submitted, confirms the scope of the contents of record, including everything that's been submitted and is available on the websites in addition to the letter from Q Team that was submitted on July 26th. Then goes into the findings of fact and conclusions of law of 4 issues. The first issue is whether all the violations should be vacated because Q Team reasonably relied on the property owner's contract to obtain all the required permits. The board made factual findings and conclusions that are reflected here and ultimately voted to deny the appeal on that basis and uphold all violations. The second issue was whether violations 1 and 2 concerning the removal of vegetation less than 3 feet in height without a permit should be vacated, and the town with no objection abandoned these arguments, and so essentially that moots the appeal on these points, and so the decision reads that the board declines to address those arguments or make any findings on those points. So the third issue was whether violations 3 and 4 concerning the removal of alleged hazard trees should be vacated. This reflects the findings on this point, and ultimately the board concluded 5-0 to uphold violations 3 and 4. Everybody happy with those findings? I think that's the most detailed of the findings. Seeing nodding heads. And the fourth issue the board addressed was whether violation 5 should be vacated or consolidated with violations 3 and 4 because they are duplicative. And on this point, the board was split 4-1. So ultimately denying that ground of the appeal. And so we'll now take what I would suggest is the board take a vote to deny the appeal based on the findings and conclusions of law reached at the July 26th deliberations as reflected in this draft written decision.
So I have a question, Stephen. Two of the board members who were part of this meeting last time are not here tonight to vote on this. Is there anything we should be concerned about with regards to that?
The decision that was reached at the last meeting was a preliminary decision only. So I can make a notation in the written decision reflecting that we have a quorum of the board taking the ultimate final decision. So in my view, that is legally adequate, but I would suggest opening it up to the parties on this appeal to argue otherwise.
So yeah.
Yeah, I don't have an argument to the contrary. I just want to make sure, and I think the record is clear that it's the case, but that the folks who are here were also members present at the prior meeting and participated. That's my recollection, but I just want to confirm that that's the case.
That is the case. Yep.
Thank you.
Eric, do you have any?
No objection in proceeding in the way that you're proposing.
Okay, very good. So if I heard you correctly, Stephen, we're just looking for a motion now at this point to deny this administrative appeal. Is that correct?
Deny the administrative appeal based on the findings and conclusions reached at the July 26th hearing and adopt the written decision as presented with that modification to note that we have 2 members absent.
I'm going to do a so moved to that. Do I have a second?
I'll second that.
Do we have any further discussion before taking a vote? So roll call vote, all in favor of denying the appeal. David Murch, yes.
Fred Miller, yes.
P. Lockwood, yes.
Okay, very good. So Attorney Wagner, you'll take it.
I'll make that modification and provide this written decision at the end of tonight's meeting to Sandy so she can make that available to you to all come into the office to sign at your earliest convenience. And I would ask that the last person to sign add the date of the written decision above, but the date of the decision will be tonight.
So as a matter of clarification, those signing it, will it be all board members or only the three?
Just the three that voted tonight.
Very good. So next on our list is public hearings on additional administrative appeals. We have 1, 2, 3, 4, 5. Clearly discussed that we're not going to discuss all of them, but just for the sake of ease, can I get a motion to take all of these off of the table?
Make a motion to take all these off the table.
I'll second that. Any further discussion before we vote? All right, David Murch, agreeing to take these tabled items off of the table? Yes?
Brenda, yes.
B. Lockwood, yes.
Okay, very good. So next on our agenda is administrative appeal, re-notice of violation issued 12/21/2021, applicant Duran Excavating, location 18 Fernwood Road. Description administrative appeal form, notice of violation. So this is one that we had discussed at our previous meeting. We were looking at the timeliness of the submission, and as part of that, we asked Attorney Wagner to provide some additional information with regards to good cause exception, to which we did receive a substantial overview to that. Attorney Wagner, what do you recommend? Do you recommend that I read this for the record? What should I do?
I don't think you need to read it for the record. I think we can just agree that it's part of the record, absent any objections from any of the parties to that effect. I think I would summarize it as consistent, though more detailed than the opinion I gave to you at the last meeting, which is that for a good cause, you essentially need to look at the special circumstances of this case and ask if they are such that it would be a flagrant miscarriage of justice to strictly apply the appeal deadline in this case, and whether an exception should be made. And essentially, you look at the totality of the circumstances, and really you're guided by the principle of fairness, and that this rule, this exception is really the exception to the rule. So it's really extraordinary circumstances that you need to find are present here. So I'm happy to entertain any questions from the board on that standard. Are there any?
I don't have any. Fred or Pete, please feel free to ask.
I don't have any either, Dave.
Okay, so seeing the questions on that, what I would suggest, since Attorney Braun wanted to address this collectively with the timeliness of the whitetail issue, I think it makes sense to turn it back over to the parties to just summarize again very briefly their arguments with that in mind. Now, I think technically, correct me if I'm wrong, it was actually a motion by Attorney Wyckoff to dismiss the appeals as timely. So I think I would start with Attorney Wyckoff on this.
And if I may, Stephen, before we begin arguments, I'd like to do two things. One is to primarily, again, make requests that we table these hearings to provide opportunity for the parties to continue to work towards resolution of this matter. Since we were here at the end of July, there have been significant steps towards resolution. We have submitted to the town a new and complete restoration plan. We did that on or about July 21st. To this date, being August 30th. I don't believe we've been provided or received a substantive response from the town as it relates to that restoration plan. My understanding is that the town and their council have made 2 separate site visits to the property related to this restoration plan since that time, without any substantive response to that proposal. And similarly, we have also submitted to the town some 8 days ago now a proposal to reach a consent agreement as it relates to all of these issues, so that the parties can move forward towards a resolution. And as of today, we have not received any substantive response from the town. Now, I haven't personally received this communication, but my understanding is that Attorney Wyckoff is prepared to provide us some update or response tomorrow from the town. And if in fact that is the case, it would seem very prudent to use what are limited resources and not inexpensive resources to further those discussions towards resolution, rather than, again, spend hours of time and, quite frankly, thousands of dollars on these hearings. I also have a concern, given that this issue was actually brought up at the last meeting, where other board members were present who are not now present, whether or not it's proper, or if we should continue these hearings to the next specially assigned date, where all of the board members that were party and participating in that prior hearing can be present to continue these deliberations.
Attorney Wyckoff?
Yeah, sure. I'm happy to respond. So, on behalf of the town, we have received a restoration plan from a consultant that has been retained by Management Controls, and staff from the town did visit the site. I don't know, I think it was about 2 weeks ago or something on that order. I visited it just last week with our consultant, and the town is currently working on providing comments relating to the restoration plan, so that's true. As to the consent agreement, it's true that we received comments to that 8 days ago. I would point out they've had it for, I think, 5 months. We circulated a draft of that 5 months ago, and we received comments 8 days ago. So yeah, we're still working on the comments to that. And we will be providing those in due course when we're prepared to provide those comments. As to whether or not this should be continued, the town opposes a continuance. There is a quorum of the Zoning Board of Appeals present here today, and we think that we should proceed. This has been going on, and we need to continue down the path that we're on in terms of resolving the appeals. That doesn't mean that the parties can't continue to talk, and the parties are talking. And, you know, the town is working on providing comments, but I don't think that impacts whether or not the Zoning Board of Appeals proceeds here today. The fact of the matter is, as we sit here right now, there is not an agreement. We're working on seeing if we can find an agreement, but we're just not there yet. So for those reasons, the town would oppose continuing the hearing.
Attorney Ratchin, I recognize you don't have any appeals tonight, but I'd like to give you a chance to speak to this.
Yes, thank you. I appreciate that. I guess I would echo Greg's, or I should say Attorney Braun's comments about the fact that we're seems a lot of time and energy and legal bills when we are so very close. And we also have 2, as I understand it, dates appointed in a month from now. The other thing I would say, just from a due process standpoint, is the fact that, you know, it's going to be a tough standard for the applicant when they only have 3 folks present. And I guess I would ask Attorney Wagner to talk about what if the vote would have to be 2 out of 3 or 3 out of 3. Is it present and voting, or is it a quorum of the board that is required when it comes to the final vote? I just don't. I guess I'm not familiar with your bylaws. Maybe we need to have a look at that to see what would carry the day. Because I am concerned about, you know, if you have only 3 members present, if a quorum of the board is required, meaning 3 of 5 as opposed to 2 of 3, that is certainly a significant disadvantage for the applicant here.
So this is Stephen Wagner. I guess what I would ask for is, since I was not aware that we'd have just 3 members, so I didn't take any time to look into this issue. So maybe just a brief recess to let me take a look at the ordinance and the bylaws, and then I can provide the board some guidance on how to rule on this issue. So I just have 3 minutes.
And certainly do that. I have the bylaws up in front of me, Stephen, if you want me to read it, but if you want to take some moment to review, it's up to you, whichever works best for you.
Sure. Well, I mean, I'm certainly happy to defer to you on, do the bylaws speak to whether there's is the vote majority of those present or a majority of the total board?
Sure. So according to the bylaws, Article 4, conduct of meetings, workshops, and executive sessions, Section 3, a quorum shall consist of 3 ZBA members. All actions shall be determined by a vote. A majority of the quorum present is needed to pass any motion. When a vote on a motion ends in a tie vote, the motion fails. The determination of a quorum for any vote shall not include any member who cannot participate in that vote due to a conflict of interest.
Thank you for reading that. And I'm also looking at Section 3A, or no, rather 3B, which says that a concurring vote of the majority of the members of the Board of Appeals present and voting shall be necessary to reverse an order of decision. So I think that squarely addresses that question, which is that it's a majority of the members present. So 2 out of 3 will prevail tonight. In terms of the broader question of whether you should grant the continuance or not, my advice from last time remains the same. You know, I do think that the requirement to address an appeal is primarily to benefit the appellants. At the same time, there's absolutely an interest in efficiency and fairness, and an appeal has been pending, and the appellants could have withdrawn the appeal if they didn't want to continue with this, but of course that could hurt their appeal rights. So those are all the factors that the board has to consider. The same conversations we've had before, and at the end of the day, it's really a discretionary matter for the board. I'm not terribly persuaded that there's a significant due process concern here, as we do have a clear quorum. But certainly if the board felt that it wanted, for various reasons, to have the full membership of the board here, that I think is a decision squarely within its discretion.
Sure. Thank you, Attorney Wagner. So Fred and Pete, as you know, with any meeting, we can't guarantee which members are going to be here. Both of our members had emergency issues that came up, which prevented them from coming. At our next meeting, we have no guarantee that some other emergency issue could take either one of you or myself out of a meeting. So given the fact that we cannot count on consistent membership at each meeting, I don't, I believe we should continue. And as in regards to the request to continue to table these, I am of the same mindset as I was the last time, that given we have some parties requesting this, some parties not, given that it's not a consensus, given that not all parties are in favor of tabling, I would choose to deny the request to table. But Fred, Pete, any conversations before we sort of take a vote on this?
Okay to continue.
Yeah, I'm interested in continuing. I mean, I would appreciate if we had full members, but at the same time, I'm confident that we can move forward.
Okay. So Attorney Wagner, I can't remember last time we had this issue come up, and I think we did a vote to, does that sound correct?
Yeah, I would make a motion to deny the request to table the matters.
So so moved. Do I have a second on that?
Second that.
So any further discussion, Fred or Pete? So all in favor of denying the request for continuance, David Merch, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, very good. So moving on then.
Yeah, I think the floor goes back to Greg now.
Yep.
And in fact, I believe it's to Attorney Wyckoff, as he was the one that made the request to deny.
Okay, yeah, sorry, I thought you said you had two procedural issues you wanted to discuss first, but I agree with you.
The first was the quorum, and the second was the general request for a table.
Got it.
Okay, can I share my screen to kind of help you follow along with my argument here? Can I go ahead and do that? I can do it just I'm asking for permission, I guess, is really what I'm doing.
Can anybody answer Attorney Wyckoff's question? Bill or?
He's just looking for the board's permission, yeah.
Oh, I'm
Right.
sorry. Yeah. Yes, please go ahead. I apologize.
Okay, I'm gonna go ahead. I'll share my screen. Okay, are you able to see my PowerPoint presentation?
Yes.
Yes.
Okay, very good. So here, Duran Excavating's administrative appeal of the notice of violation relating to 18 Fernwood should be dismissed as untimely. And actually, let me ask a procedural question to the chair. Do you want me to address the timeliness of both appeals or only as to Fernwood?
Well, I know it's a good question. I know that Attorney Braun related information specific to both applications at the time. Yeah, I would say go ahead and let's hear both of them, please, at the same time.
Okay, that's fine. I'm happy to do that. So with regards to 18 Fernwood, the application for the notice to seeking the appeal is dated February 24th, 2022. And the application wasn't received by the town until March 3rd of 2022. Now, under the Shoreline Zoning Ordinance, Section 16 requires that all appeals be taken within 30 days of the date of the decision appealed from. And the notice of violation for 18 Fernwood is dated December 21st. That makes the deadline for the appeal January 20th, 2022. So the appeal wasn't received by the town until 42 days after the 30-day deadline for submitting an application for an appeal. You know, given the amount of time that elapsed, it's clearly beyond the time frame, and my understanding is that there hasn't been any evidence presented as to a good cause for the board to waive the deadline for submitting the application for the appeal. For that reason, the town requests that the appeal be dismissed as untimely. Now, with regards to 28 Whitetail, that application, so the application the application to appeal both notices of violation came in the same application. So they're both dated February 24th, and were both received by the town on March 3rd, 2022. And as I mentioned before, the deadline for filing an application for an appeal is 30 days. The notice of violation for Whitetail is dated January 28th. The deadline for the appeal was March 1, 2022. The appeal was received by the town 2 days after the 30-day deadline for submitting an application for an appeal. And for that reason, it should be dismissed as untimely. Now, I'm not aware of any facts that have been presented with regards to good cause. If Duran Excavating presents facts relating to good cause, then I would reserve the ability to present facts in rebuttal. Thank you.
Thank you. Craig, sorry, Attorney Braun, did you have just some follow-up to that?
So I'd start by reminding the board that this project was commenced back in the fall of 2021, and that the stop work order was issued on or about October 26th of 2021. All right, and so that was back in the beginning of fall of last year. Notice of violations, the first of these, weren't issued until almost 2 months later. Rob Duran, has been in this industry for more than 20 years. And during that time, he has never once received a notice of violation for any work he's performed anywhere else. He was an unrepresented individual who had no experience or history with these types of administrative issues. More importantly, and as I would expect Attorney Wyckoff might point to, and I've seen in some of the materials he circulated to the board, from the date that he was told to stop work through the period on which he submitted appeal applications, he was in constant contact with both the town and the Maine Department of Environmental Protections. He, in good faith, entered into discussions with the town aiming towards and intended to resolve the issues at hand. All right, so that's the first and foremost. The second, as this application clearly indicates, the primary argument that he meant to make through these applications was that the town had cited the wrong company, the wrong individuals per se, as it related to the alleged violations. In support of that position, I would note that after he filed his appeal the first week of March, the town immediately issued new violations against the company that he identified and told them had informed them previously that they should have correctly cited. And so the first thing I would say is that we're dealing with an individual who has no prior experience with this process and who was in contact consistently with the town towards or with the intended purpose of rectifying and curing the alleged violations. Now, that I think argument is conclusive, or the total of it as it relates to 18 Fernwood. Now, as it relates to the timeliness of the 28 Whitetail Lane, which was issued at the end of January and which by the calendar was only some 3 days late, I would note several important facts, all of which I would hope and expect the town and Alex would confirm. The first is that the town was dealing with significant staff shortages and issues in the lead up time to when that appeal was due. And Rob Duran, in fact, I believe he cites in his application, had contact with Sandy Fredericks related to the necessary fines to be paid and the materials to be submitted. And for whatever medical reasons or personal otherwise, absolutely no fault or harm to anyone, right? She was unavailable to provide either those calculations or the necessary plots and plans. That on its own slowed down his ability, again, an unrepresented individual, in completing and submitting this application. We compound that with two other things. The weekend, right, I believe the application was actually due on a Friday. That ended up being a snow day where the town of Raymond offices were closed due to inclemental weather. And so even, right, had he been able to get there, the town office was closed. And I believe that the way the schedule falls, the following Monday is a day that typically the town is closed for general business. So he was unable to otherwise submit the application on that day either. And so what did he do? He ended up filing the application on the next available business day that the town had available. And so I think given the consistent communication he had with the town, given the lack of resources the town had and the limited hours, both due to weather and due to typical scheduling, it makes sense and justifies good cause for why he would have been very modestly delayed in submitting that application. And when we speak to the harm, again, in this application exclusively, what he has argued is that the town has cited the wrong party, right? He's indicated that Big Lake Marine LLC, Big Lake Marine Construction LLC, is the proper party. And he's submitted an application as it relates to those notice of violations which were issued to that party, to that company, immediately after he submitted this application. And so I can't think of much more in the way of injustice there would be than to try to find the wrong or the inappropriate party responsible for something that it didn't do. And so I think that speaks to the timeliness issue, and it speaks to the significant good cause for why there should be an extension. I would note too that Attorney Wagner provided the memo to the ZBA. I won't really speak to its contents or the legal arguments therein, but what I would point out, and I believe, although maybe Steve wants to speak to this, is that the ordinance for the town itself allows for a waiver of the good cause or of the 30-day requirement. So if you're not just limited, I would argue, to whatever court cases or determinations might be, but rather your ordinance itself allows for a 30-day a waiver of that 30-day requirement. And I would say that means you're not explicitly bound to consider the court cases that Stephen has cited.
Attorney Wyckoff, did you want to respond to any of that?
Trying to find the right button to click. Sorry for my delay. I guess, so I have a question. We heard a lot of argument there. I didn't hear any evidence. So if the board is of the view that they just received evidence, then I'm happy to put evidence on and have Alex testify about this. But if the board doesn't, yeah, I'm looking for a little direction here because I heard argument, but I didn't hear any evidence.
Well, I have one. I would like to get some feedback from either you or Alex with regards to Duran Excavating versus Big Lake Marine Construction.
Sure.
Are they considered one and the same, or should they not be considered one and the same from the town's perspective?
Sure. I'm happy to have address that. And I'm also happy to have Alex testify about the chronology here, which the town would dispute as to how it has just been described. So maybe what I can do is maybe we just can have Alex provide some testimony here to give you some facts relating to the situation.
Sure.
I think Alex may be having a technical.
No, I'm good. I'm good.
Good. Okay, so Alex, I want to focus first on the notice of violation relating to 18 Fernwood, please. So that notice of violation was issued to Duran Excavating, and it's dated December 21st, 2021. Is that right?
Yeah, that's correct.
Oh, okay. And do you know when Mr. Durant received a copy of that notice of violation?
I don't know exactly when he received it. We did send it certified and first class. We never received the first class mailing back. So we assume that he received that one at least. And then a week later, after Christmas, sometime around the 26th, 27th, I can't remember the exact date, Rob actually came into the office and spoke with my assistant, Chris Hansen, and myself, and thanked us both for sending him the Christmas card. So we didn't send him a Christmas card. I would assume he was talking about the NOV, that we had sent the week before.
Okay, and did you have a conversation with him about the gravity of the matters raised by the notice of violation?
Yeah, I've been working with Rob on projects around the lakes for a number of years, and I like Rob. What we told him was, this is a very serious situation, and we suggested that if he didn't have an attorney, that he had an attorney really quick.
Okay, and that was at the same time you were meeting with him in that last week in December?
Yeah, correct.
Okay, now I want to switch gears a little bit and talk about the chronology relating to the notice of violation at 28 Whitetail.
Sure.
Or Duran Excavating relating to Whitetail. Now that was dated on January 28th, 2022. Is that right?
Yes, correct.
Okay. Now, when did the town consider the deadline for submitting an application for appeal to occur relating to that application, to that notice of violation?
Yeah, so the 30-day time period actually would have expired on Monday, February 28th. And there was some back and forth on this. I can't remember exactly with who over email, but the town office is closed on Mondays. So since we would have been closed Monday, February the 28th, we decided to consider the deadline March 1st, the next open business day.
And was an application? Go ahead.
As we would if a deadline fell on a Saturday or a Sunday.
Okay. And was an application for an appeal submitted on March 1st?
No.
Okay. Now, did you have some appointments scheduled with Duran Excavating relating to these matters in the time leading up to the deadline for the appeal?
Yeah, Heidi, Rob's assistant, had scheduled an office meeting for February 24th, which was the Thursday before the deadline. It was scheduled through our online portal, and the note didn't specifically say exactly what it was they wanted to meet with me about, just that they had scheduled an office meeting. And
that
that
was
meeting,
on. Go ahead.
Yep, that was February 24th.
And did it take place?
No, for some unknown reason, that one actually was canceled by Heidi or Rob, one of the two.
Did it get rescheduled?
It was rescheduled for the next day, which would have been the 25th.
Okay. Can I share my screen again here? Do you have any objection, Chairman Murch, to me sharing my screen?
I apologize. No, I don't mind. When I hear you say that, I work in the technical world, so I'm thinking you're asking, do you have the ability to? So I apologize.
Okay, good. No problem at all. So I've got a document that's up here, Alex. Setting aside the handwritten marks, the electronic document, can you describe what this document is?
Yeah, this is the email notification that Duran Excavating 11 at yahoo.com would have received when the Friday office meeting was canceled.
Okay, so that's the email. So that's the email address they were using to electronically schedule these meetings. Is that right?
Correct. Yeah.
So that's Durant Excavating 11 at yahoo.com.
Yep.
Okay, and so did the meeting on February 25th? It didn't occur, did it?
No, as Greg said, the town office actually was closed due to a snowstorm that day.
Okay, and did that meeting get rescheduled?
It was rescheduled for March 1st.
Okay, and can you describe that meeting and what you recall about it?
Yeah, so Rob came in on March 1st as scheduled, and he described that he had his appeal application, and he was missing a copy of, I believe it was a tax map, and he didn't have that for his application to submit. At that point, I suggested that he submit what he has. The issue was when he came in to get a copy of the tax map, the assessing admin was actually out. And she's the one that kind of takes care of the tax maps. The tax maps are available for download as a PDF on our website, which they have been for a decade or more, I think, at this point. And so I suggested to Rob, look, just submit what you have today. And if it's incomplete, just get the tax map in a couple of days, tomorrow, tonight, if you can go home and download it or print it, whatever you can do, but just get something in today.
Okay, so in other words, he didn't actually need anything from any personnel at the town in order to complete that application, did he?
No. Most people, typically, we don't have to provide any details for someone to submit an appeal. When they're given an NOV or a denied permit, that's really all they need from us in order to submit, other than the application, obviously, which is at the town office or on the website.
And on the day that the appeal was due, you told him that he should submit what he had that day because it was due that day. Is that right?
Correct. Yeah.
Okay. Now, did Duran Excavating submit its application for an appeal on March 1st?
No.
When did it submit it?
March 3rd.
And how do you know that?
We stamp all applications when they're received, and the date on the application is stamped March 3rd.
Okay. Did you ever tell anyone at Duran Excavating that it was okay to file their appeal on any date other than on March 1st?
No, like I said before, I had suggested that he submit what he had that day as soon as possible, just to get it in, and then if he was missing information, just get it in as soon as possible.
Okay. So now I want to change gears a little bit, and I want to ask you why you issued a notice of violation to Duran Excavating regarding the violations here. Could you describe? Can you just describe that to us? Yeah,
absolutely. So you guys may remember this all got started when we received the email from Alexis Savavlos from Maine DEP. And in that email, she had included previous emails. I was copied on this email. She was corresponding with Heidi. I believe that was specifically Duran Excavating 12. They have two email addresses, 11 and 12. And in that chain of emails, I relied on the email signature, which the first business in her email signature is Duran Excavating, which is, also the email address is duranexcavating12@yahoo.com. So that was kind of the first, real reason I believed that the professional that was doing the work was Duran Excavating.
In the email address that was used to submit that permit by rule application, do you recall what that email address was?
I believe it was Duran Excavating 12 or 11, but I'm pretty sure it was 12.
Okay. And any other reasons you issued the notice of violation to Duran Excavating?
Yeah, so the emails from Alexis that continued to come in that day included photos, and photos that we received showed the equipment on site was lettered with Durant on the back. So as we know, that's Duran Excavating's equipment.
Okay, so the equipment that did the work was actually labeled Duran Excavating.
Correct.
Okay, very good. Thank you very much, Alex.
Yep.
Okay, now I'm going to share my screen here in just a moment here again. So here's a copy of the appeal that was submitted relating to this violation. And as you can see from the first paragraph, it says Duran Excavating wasn't the hired contractor for the project, and says Big Lake Marine Construction did the contract. I just want to point you to that. And it's important because there is no entity called Big Lake Marine Construction LLC. It doesn't exist. There isn't one. If you go to the Secretary of State's website, it's just not there. What is there is an application for a mark for Big Lake Marine Construction was submitted by Mr. Durant. And I'm just going to blow this up for you so that you can see it here. This is a copy of the application for registration that was submitted in 2015 to the Maine Secretary of State's office by Mr. Durant. And in this, he identifies the term Big Lake Marine Construction as what's constituting a mark. And so he submitted that, and he represented that he, Robert Durant, was the owner of that mark. And the point being here, this is really what's going on here is that it's an attempt by Mr. Durant to hide behind corporate formalities. So this notice of violation was issued to Duran Excavating because the email address used to communicate with the Department of Environmental Protection regarding the work being done here was sent from a Duran Excavating email address. The signature had Duran Excavating on there. That same email address was used to schedule meetings with Alex Soroy regarding the matters. The equipment used to do the work was labeled Duran Excavating, and the entity that Mr. Durant points to as who did the work, Big Lake Marine Construction, doesn't exist. Okay, now being charitable, let's assume he uses Big Lake Marine. Well, that is an actual entity. That is an LLC that Mr. Durant is a member or manager of. Now, here's the annual report filed in 2020 by this Big Lake Marine with the Secretary of State's office. And it states that its business is marketing and brokering the sale of boats, purchasing boats for resale, selling boats, and engaging in sale and brokerage of boat accessories. We're not dealing with boats here. We're not dealing with buying and selling boats. We're dealing with construction. So my point is, the party that really did this is Duran Excavating. That's who's communicating with the Department of Environmental Protection. That's who's communicating with the town. And this is, anything else is really just an effort to try to, it's basically like a shell game trying to hide behind corporate formalities. So, in other words, there's no good cause for giving an exception to this deadline here. Duran Excavating had knowledge of the notice of violation against it. Alex Soroy recommended they get counsel back in December. They submitted, as to Fernwood, the application was submitted 42 days late. There isn't going to be any flagrant miscarriage of justice if you don't waive the deadline here. The facts are not so extraordinary to suggest you should waive the deadlines, and you should dismiss the appeal as to Fernwood as untimely. Now, as to Whitetail, it's the same kind of story. They knew this. They knew this was out there. They knew that they had notice of the violations. Alex said, you need to submit everything you can on March 1st. They chose not to. That was their choice. There's not any miscarriage of justice. There's nothing unjust here. And then beyond that, substantively, the notice of violation was properly issued to Duran Excavating for all the reasons that I just described. So in the first instance, you should dismiss these appeals as untimely. And in the second instance, on the substance of it, these violations were properly issued to Duran Excavating. Thank you.
So Attorney Wyckoff and or Alex, given the information you presented with regards to Big Lake Marine and their business model, why then did they get notices of violation issued in March?
I can answer that. So when we received the appeal filed by Mr. Durant, and he said, did not me, Big Lake Marine Construction, then, the town researched it and came up with the facts I just described to you about Big Lake Marine Construction not actually existing, and then find out that there's a Big Lake Marine that does exist relating to Mr. Durant. So out of abundance of caution, the town issued notices of violation to those, to Big Lake Marine LLC in the event that the appeal that he submitted were, if this board were to grant that appeal, we submitted it out in abundance of caution to make sure that there was a violator relating to these violations and that a notice of violation had been issued to. Alex, do you have anything you want to add regarding that?
The only thing I want to add, I don't know if it's necessarily directly an answer to that question, David, but I don't believe Big Lake Marine has anyone has a DEP certification to be working in the shoreline zone. Any contractor that disturbs a certain threshold of material in the shoreline zone is required to be DEP certified. Durant Excavating, I believe, is, but I don't think Big Lake Marine is actually DEP certified.
Attorney Braun, can you just speak briefly to the differences between Duran Excavating and Big Lake Marine?
Sure. So they are different businesses that from time to time merge or find themselves on the same sort of job site. But it's clear here from the invoice and contract that was provided that the intention was that this work would be done and it would be contracted with Big Lake Marine and Big Lake Marine Construction LLC. Outside of that, it sounds as though, and I would argue that the town kind of wants to have its cake and eat it too. In one instance, it wants to argue that the LLC should be disregarded or not be considered part of this, and yet we've got a second alternative notice of violation as it relates to that still to go. And so, for me, what it speaks to is really an inability by the town, outside of our indications and representations, to properly indicate which party is actually responsible. And outside of Attorney Wyckoff's arguments that this is the shell game, which is not true, naming the correct party is important. That is something that is relevant to this case. And so I would argue that should be considered by this board. And further, what I heard in Alex's testimony here, his statements, is that Rob Durant was engaged and in communication and actively in contact with the town as it related to the filing of these appeals. And it sounds like Alex indicated or instructed him to file an incomplete application on the due date, which itself would be something that would be ripe for potential appeal or challenge. And instead, what Rob Durant did was make sure he could file a completed application. And so I think that inconsistency or fact also speaks to what should be considered good cause to extend the deadline.
Thank you.
David, is it possible through you, can we ask if Big Lake Marine is DEP certified? Because if they aren't, I would be curious why they're engaging in shoreline restoration projects and if they're hiring an individual that is DEP certified, like Duran Excavation, to actually do the work, since they're not actually certified to do it.
Actually, Alex brings up a fair point. I was going to ask specifically, how do Big Lake Marine and Duran Excavating work together? What is their business model in working together? That's for you, Attorney Braun.
Sure, and at this moment, I can't provide any more detail or explanation than what we provided today.
So, Attorney Wagner, I seem to feel like we're at two issues here, one of which is timeliness, the other of which is the appropriateness of the notice of violation. Is it appropriate to go to Duran Excavating, or is it appropriate to go to Big Lake Marine? My concern is if one or both is dismissed in terms of timeliness, then we skip over potentially the fact that maybe they should never have been issued at all in regards to going to the proper entity. I don't know if that makes sense, but I just sort of, that's what's going on in my mind right now. I kind of need some assistance thinking that through.
So I understand why you're considering this, because I think the reality is, it is all interrelated. The ultimate question is, who is the responsible party, and did they have, fair notice of that? But I think from a jurisdictional standpoint, as kind of frustrating as it can be, I think it is important that we do take these issues up separately, because whether the appeal was timely or not goes to this board's jurisdiction. So I think you have to address that first. And I think that's kind of a two-parter. One, factual question of when did the actual application get in, and is it untimely or not? I think in the first case, it's pretty clear that it was untimely. I think in the second case, you should take a close look at when was it submitted and what are the submission requirements to make that actual determination as to whether or not it was timely or not. And then it's the good cause analysis, and it's fairness, and it's really up to the discretion on the board. And I think you should just address that question on its own first. And if you dismiss one or both of the appeals as untimely, then no, you don't get to the question of was it the properly named entity, and essentially the town prevails on that because the appellant failed to file a timely appeal.
Thank you. So, Fred and Pete, I'd like to look at these individually. The first one's going to be specific to Fernwood, in which the notice of violation is 12/21/2021, and the application received on March 3rd, 2022. Given the information with regards to good cause exception, I don't necessarily see anything there that would lead me to believe there's good cause to allow the appeal to go through. My other concern is when I do look at the emails that went through with the DEP as well as carbon copies to Alex and with Rob Duran, I do see email signatures for Heidi Stiles in which both Duran Excavating and Big Lake Marine Construction are noticed in or noted in the signature line. So I'm not convinced of the argument that there was it took over 30 days to decide where this was going. Anyways, Pete, Fred, please give me the feedback on this first one for 18 Fernwood.
I definitely think over the time period that they are allowed to do it, and I don't think it's any good reason for why they should have gone that far.
Right, and I would agree with that as well, David.
So our ordinances, which I can't find here. Here we go. So in our ordinances, the appeal procedure, making an appeal, it does indicate that while an administrative appeal or variance appeal may be taken to the Board of Appeals by an aggrieved party from any decision of the code enforcement officer, such appeal shall be taken within 30 days of the date of the decision appealed from, and not otherwise, except that the board, upon showing good cause, may waive the 30-day requirements. So I just want to make sure that we are in agreement based on our ordinances that good cause has not been shown here in regards to Duran Excavating 18 Fernwood Road and the submission of the appeal. Would you agree with that, Fred and Pete?
I agree with that.
I agree with that.
Okay, so Stephen, at this point, I believe I would be making a motion to deny this administrative appeal due to it being submitted beyond the 30-day submission timeframe. Oh, you're on mute, Attorney Wagner.
All right. I would just add to your motion that the board also finds no evidence to support a finding of good cause to waive that appeal deadline, and for that reason, the appeal is denied. And
So
sorry, just make clear which one you're talking about. I think we're just talking about
only 18 Fernwood, yes. Yep. So I'm going to say so move. Do I have a second?
I'll second that.
Any further discussion before we go to vote? So David Murch in favor of denying, yes.
Fred Miller, yes.
E. Lockwood, yes.
Okay. Sir Attorney Wagner, you'll follow up for us with that?
yes. I guess that was a final decision. So I will follow that up with a written decision in 7 days for you to sign. I don't think that requires bringing it back before the board. If you disagree and you want to stick with our prior procedure, we'll just, I guess, go back and make a motion to clarify that that motion was a preliminary finding and you would like me to prepare a written finding to review and then finalize at your next meeting.
I see no need to do that. I'm good for you to write up the final decision as is.
Okay.
So now moving on to the administrative appeal for 1/28/2022, Duran Excavating for 28 Whitetail Lane. Again, the subject of timeliness of submission. Let's see. So if I understood correctly, the first valid day, the last day, given office is work schedule would have been March 1st. The submission was on March 3rd. The paperwork, the paperwork we received indicates a February 24th, 2022 date on it, which corresponds to the first meeting date, which was scheduled and subsequently canceled by Duran Excavating. Then follow-up meeting on the 25th, or a rescheduled meeting, I should say, on the 25th, had to be canceled due to a snowstorm. And then the first was March 1st was the first available day. March 3rd was when it was actually submitted. There was information presented about requesting some additional information in order to complete the application, although we did hear from Alex that that information was not necessary in terms of submitting the application. I would like to hear from you, Fred or Pete, your thoughts on this.
I guess the only concern I have is that Alex had asked him to give him, what he had at that point, which I believe was March 1st, and that he didn't even file what he had, and then come back again with the tax map that he didn't have paperwork.
And that's my thought too, David, that, it sounds like Alex gave him every opportunity to try to file what he had in a timely manner, and for whatever reason, Mr. Duran chose not to. His choice at that point. But I think Alex did what he could to try to help them with the process.
Yeah, I feel the same way, given how Alex spoke to that, indicated that it should be submitted on that day and that it could be without the tax maps.
And he was at the town office at that date too. So he was already in the building.
That's correct. Yep. So if we go back to, too many windows open. If we go back to our appeal procedure, again, must be taken within 30 days of the date of the decision appealed from, and not otherwise, except that the board, upon a showing of good cause, may waive the 30-day requirements. So Pete and Fred, are you indicating that you're not seeing good cause here?
I'm saying that, no, I'm not seeing that, David. I mean, if he had, he would have filed what he had on the first.
Nothing. If he thought he needed to have another couple of days, he could have mentioned that to Alex. Say, can I come back, in a couple of days with the rest of the paperwork? And I think Alex stated that he said he should file what he has that day to at least get it started.
Yeah, and that's sort of what I'm hung up on too, is the fact that the code enforcement officer indicated that it should be submitted on that date, and additional information can be provided afterwards. And that the maps were not required as part of the submission. So I have a motion on this.
I make a motion on this.
Motion to what, Fred?
Not to deny this violation.
So to deny this appeal.
Right.
On the grounds that it was submitted beyond the 3-day.
Correct.
Without good cause. Do you want to second that, Pete?
Yes, I'll second that.
Attorney Wagner, is there anything you want to add to this? You're on mute again. Attorney Wagner, you're on mute.
Sorry.
That's okay.
I would just amend that to say, based on the factual findings that you all just reached a consensus on.
So, given that motion, all in favor of denying this appeal? All in favor of denying? David Murch, yes.
Fred Miller, yes.
Pete Lockwood, yes.
So same procedure there. I'll take that as a final decision of the board with clear findings and conclusions, and I'll memorialize that in a written agreement within 7 days to provide to Sandy for the board to sign.
Good. So, on administrative appeal, notice of violation issued 3/10/2022. Applicant Gregory Duran, Esquire, on behalf of Big Lake Marine LLC, Robert Duran, member and manager, location 18 Fernwood Road. Description, administrative appeal from notice of violation. So now we have to look at the timeliness. So notice of appeal was on 3/10/2022. The information that I have in front of me shows that the appeal was submitted and received on April 8th, 2022. So April 8th, so March 10, April 8th, it's within a 30-day time frame. Are we in agreement that this is timely submitted? Pete, Fred?
I'm sorry, I was busy looking at this. Say that again.
Yep. No, I'm just saying, would you agree that this was submitted in a timely manner? This appeal?
And what was the date again? The 2 dates?
It was, the notice of violation was issued on March 10,
Yeah, 3/10.
2022, and it was stamped, the appeal was stamped as received on April 8th, 2022.
Sounds like it was within the 30 days.
Right.
Yeah, there's no question there. So, Attorney Wagner, can we just move on, or do we have to sort of take a vote here to say, yeah, this meets this?
Yeah, why don't we just take a vote that on the finding that the application for appeal was timely submitted.
Yeah, so moved. Do I have a second?
I'll second that.
Any final discussion before we vote? David Murch in favor of moving forward? Yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. So, Attorney Wagner, you'll have to.
Sure. So I can.
Procedure.
Yep, I can again just provide a brief summary of the procedure that we've been following here. So we've determined the application to be complete. Next step would be, that it's timely. Next step would be to determine that we have a complete appeal application.
Now, not seeing anything here to indicate that it is not complete. Fred?
I don't see any either.
Okay.
Are you good with this, Pete? That it's
Yes, I'm good with it.
okay. Very good.
So I'll just take that as a consensus that the application is complete. The next step would be for you as the chair to briefly summarize the appeal, though I think you already did that at the outset. The next step would be if any of the board members have any bias or conflict of interest they would like to disclose on this case?
I don't have it.
I don't have any.
Any motions from the parties to that effect? Seeing none. So the board should again determine jurisdiction by citing to the ordinance of what gives them jurisdiction to consider an appeal.
I'm assuming this falls under our shoreline zoning provisions, section 16, administration, making an appeal. So section 3, subsection A, further subsection 1, an administrative or variance appeal may be taken to the Board of Appeals by an aggrieved party from a decision of the code enforcement officer. Such appeal shall be taken within 30 days of the date of decision appealed from, and not otherwise, except that the board, upon showing good cause, may waive that 30-day requirement. So my understanding, based on the ordinances, is that we do have jurisdiction to hear this appeal.
Are the other board members in agreement?
Yes.
I agree.
Okay, and I think we have consensus, we have jurisdiction, and I think within that I heard a determination that there was standing as well. So the next step for the board would be to open up the public hearing. The order of presentations we've been following would be the appellant, so Attorney Braun, to start without interruption, and then questions from the board. Sorry, Attorney Wyckoff.
I have a procedural motion to make regarding this appeal.
Sure, yep, now would be the time for that. Thank you.
Okay, very good. I'm going to share my screen. So the Big Lake's appeal should be dismissed in part for failing to comply with the Shoreline Zoning Ordinance's procedures for appeals. Section 16G3A2 of the Shoreline Zoning Ordinance, which is at page 61 of the ordinance, provides that appeals are made by filing a, quote, concise written statement indicating what relief is requested and why it should be granted, end quote. Now, as to the notice violation for Fernwood, Big Lake's only ground for appeal for violations 1, 3, 5, 6, 9, and 10 is that it denies the allegations that violated the ordinance. In other words, it doesn't provide any explanation as to why the appeal should be granted for those violations. So for that reason, it doesn't comply with the ordinance. And it doesn't comply with what the ordinance requires that appeal needs to consist of. Now, I provided a citation to a law court decision from 2015, Campbell v. City of South Portland. And in that case, the law court considered a similar situation where the ordinance required a statement of grounds for appeal, but the grounds weren't provided. And as a result, the law court determined that the appeal couldn't go forward for failure to comply with the written notice requirements for the appeal, and also held that any oral arguments or contentions at the hearing before the Board of Appeals couldn't cure the deficiency. So here, the town requests that the appeal as to violations 1, 3, 5, 6, 9, and 10 be dismissed for failure to comply with the Shoreline Zoning Ordinance's requirement that an appeal contain a concise written statement as to why the appeal should be granted.
Can you repeat to me those which violations?
You bet.
Attorney
Yep.
Wyckoff?
1,
Yep.
3, 5, 6, 9, and 10.
Attorney Braun, did you want to respond to that?
Sure. The ordinance says a concise statement, right? Concise, explicitly to the point, right? Short and straight. In this instance, Big Lake has denied committing conduct which constitutes a violation. That on its own is sufficient for the purposes of the statute. Simple, straight to the point. It did not, and it denies that it committed the violations in question. Thus, that is the basis of the appeal. Further here, I would note, and I don't know if it should be taken up just now or as part of the broader argument against this violation, is that this board has just denied appeals and upheld violations against Duran Excavating LLC for exactly, I mean, carbon copy the exact violations for which Big Lake Marine LLC is now being asked to be found to have committed. And so I would argue two things. One, as Attorney Wyckoff himself just noted in the moments before this hearing commenced, that Big Lake Marine has nothing to do with excavating. And as Alex Soroy indicated, there's potentially a question as to what the licensing is related to this company. Additionally, with the finding that Duran Excavating now was responsible for those violations based on the denial of the prior appeals, that this notice of violation against Big Lake Marine should be dismissed.
Thank you, Attorney Braun. Attorney Wyckoff, can you repeat to me, please, the section of our ordinances that you noted?
Yes, of course. It's on page 61 of the ordinance, and it's section 16G 3A2. So it's right below the section in the ordinance where you're just looking at it a moment ago when you to determine whether you had jurisdiction or not.
Okay. Yep, got it. Thank you.
Okay. I have a question. Is Attorney Braun, are you saying that Big Lake Marine does not do construction work?
I'm saying you just found that Duran Excavating LLC was responsible for these exact violations. And based on that finding and the facts as presented by the town and the town's council, it appears prudent to dismiss this appeal against Big Lake Marine LLC.
So you're seeking the dismissal of your own appeal?
I'm seeking the dismissal of your notice of violation.
I'm listening. I'm just looking up some information. Attorney Braun, do you have, and looking through an invoicing here, estimate, that's, no, I'll take that. I'll take back that. It's not really a question, so. I guess, I mean, I am seeing in an information packet specifically stating agent information, Big Lake Marine Construction, Phase 2, Big Lake Marine, an estimate coming out of Big Lake Marine Construction, outline what will be done by Big Lake Marine Construction. You have to bear with me here. I want to make sure I'm looking at the correct information. So Attorney Braun, am I correct in that the information submitted to the Zoning Board of Appeals, what I have in my hand, just a document of 1, 2, 3, 4, 5, 6, 7, 8 pages, one of which is essentially a summary document, authorization letter, the appeal application, zoning map, and then basis for appeal document, which is 3 pages. Am I correct in that is all that was submitted for us
That's
to
the entirety of the appeal application.
Pete, Fred, I would appreciate some input here.
Sorry, Jared Merch, what's the date of that document that you're referencing?
Date on the cover letter is April 7, 2022. So there isn't very much information in the submitted documents, although information submitted for Duran Excavating does include, you'll have to advise Attorney Wagner if I can use this information. But I mean, it includes permit by rule notification forms in which Big Lake Marine is identified, includes an estimate by Big Lake Marine Construction specific to 18 Fernwood Road. Everything I see here, which is in another appeal submission, indicates that Big Lake Marine Construction is appropriate in being issued this notice of violation.
So I think that the question before the board that's been raised, Wyckoff, is whether the appeal that was filed, the April 7th document, does that, in the board's opinion, contain a concise statement of the grounds for appeal? And Attorney Wyckoff's pointed you to a case, Campbell v. South Portland, where the court didn't reach the merits of a contention because that party did not, in the court's words, properly present this challenge to the board. And the court talked about how the ordinance established a notice requirement that the applicant must meet to pursue a particular argument. Particularly, the court quotes that says that it shall be on forms approved by the Board of Appeals, and the aggrieved person shall specifically set forth on said form the grounds for said appeal. So you're dealing with it, it's not a verbatim match. So I don't think that the case necessarily directly controls your decision. That's my opinion. I would advise you that ultimately the question for you should be if this filing put the board and the town on sufficient notice that Duran was, or that Big Lake Marine was challenging the basis of the violations. And so Attorney Braun has argued that on its face, it clearly challenges the factual allegation that the conduct was in violation of the ordinance, and that's sufficient notice. So I think that's the question for you is, does it provide the world essentially sufficient notice that this party is challenging the notice of violation and everything in there? In my opinion, you don't have to spell out every single argument. So I think it's a factual question for you to take it. I think you've identified the right document. Take a look at that and ask if that puts everyone on sufficient notice of what's being challenged here.
So, thank you, Attorney Wagner. So Fred and Pete, I review this. I understand where the town is coming from, but it is, I wish more information had been submitted in advance, because it would be nice to know what direction applicant is coming from, but it is specifically stated denies the allegations, and that's consistent across all of these. And so I am open to accepting that and listening to discussions, although it bothers me now that discussions may have to take a lot longer than what I would like, given that we have minimal information in the document. So, but Fred, Pete?
Well, I don't think I even have that, what you're looking at. So I can't find that. So is there a date onto that, or did we get on the email?
It was something provided by Sandy, April 7th, 2022.
I did read that earlier today, David. So I know I've seen it. But I haven't had a chance to pull it up on my screen right now. Was that part of the zip file, or is that something separate?
This is something Sandy sent to us a while back.
I can do a reply all to our last email chain and circulate that. Bear with me.
I mean, so that I'm clear, we're discussing whether or not all the board members actually have the notice of appeal filed by Big Lake Marine LLC, dated April 7th and received on April 8th.
That's correct. Yep.
All right. And then that, I guess, would raise a concern for me in that two of the board members seem to indicate they don't have it before them, yet we've already established or appear to have established based on that proposed or purported review during this proceeding that the application was complete and timely and included all of the necessary material.
So I disagree with the characterization that the board has said that they haven't received this or haven't found it. I think everybody has stated previously that they're familiar with this. I think there are just a couple of folks struggling to identify the exact document in the sea of documents. So I think just bear with me as I circulate that decision to everyone. But you are right, Attorney Brown, that there was a motion to find the document complete, and so I think that the board, if it chose not to reconsider that motion, would effectively be denying Attorney Wyckoff's request anyhow. So you don't have to procedurally necessarily take any action if you agree with Attorney Braun that this this is sufficiently complete application.
I think we're waiting on Fred and Pete to confirm that you have an electronic copy, or at least the paper copy, available to you now.
I haven't received it yet.
I have not sent my email yet, so I apologize. It's just having a slow computer day. I've sent it, so those board members should be receiving it shortly. So while we're waiting, just to set this up procedurally, I guess I'd suggest a motion to deny Attorney Wykoff's motion to dismiss this appeal as incomplete, or dismiss the violations cited as incomplete. So if we can get a motion and second on that, that'll cue us up to take a vote.
Just to be clear, I'm arguing that the appeals fail to comply with the requirements contained in the Shoreline zoning ordinance for an appeal, which I think is a little different than what you just said.
You would argue that that's different than saying an application is incomplete?
I mean, I think my contention is that the ordinance requires that a written notice of appeal include a concise written statement indicating what relief is requested and why it should be granted. And that here, the concise written statement indicating why the appeal should be granted is missing for the specific violations identified.
So I guess you would argue then that it's a substantive determination and not a procedural one.
Well, I mean, I guess so. I mean, I guess it depends when you look at it, but I mean, you can look at the appeal and you can see what the ground is, and it denies the allegations. It's violated the ordinance. Okay, that doesn't really say why an appeal should be granted. It's a denial.
So can you perhaps rephrase your motion again for the board so someone can make a motion to approve or deny?
Sure. The town requests that the appeal as to violations 1, 3, 5, 6, 9, and 10 be dismissed for failure to comply with the Shoreline zoning ordinance's procedures for appeals.
So is there a motion from the board to grant or deny the town's motion to dismiss the appeal as it pertains to those violations? You're muted, David.
Sorry. I will make a motion to deny the request.
Is there a second?
Is there a second?
I'll second it.
So now the issue's queued up for further discussion. So did that buy sufficient time for the email to go out?
I still haven't gotten it yet.
Did anybody receive it?
I did. Yep.
I have not received it yet.
Let me.
Oh, it looks like I replied to a chain that only had you, David. Would you mind circulating it to
Yeah, I get it forwarded. Yep. Just got sent.
Yeah, I've just received it.
I have it now too. Yeah.
Fred, Pete, just let us know when you've had a chance to review the document, please.
Yeah, so, yeah, we're looking at 1, 3, 5, 6, 9, and 10, is that correct?
That's correct.
Okay. All right, I have it. I'm all set.
Okay. So we're just considering our ordinances in which it states such appeal shall be made by filing with the Board of Appeals a written notice of appeal, which includes a concise written statement indicating what relief is requested and why it should be granted. I mean, I will agree. It's very concise, and I do see that Big Lake Marine denies the alleged violation and maintains that the project and the work performed by Big Lake is in conjunction with the project met the requirements of permit by rule. So I'm not, to me, there's sufficient there to move forward with this.
I would say, David, I'm hesitant as well. I mean, there's not enough details answering all that we've seen as far as the photos and everything that's been presented so far.
Oh, to be clear, I'm not hesitant. I'm willing, I believe we should move forward with this. Now, do I like the fact that there's not a ton of information in this? No. But I trust Attorney Braun will provide the information that we need. But relating back to the question at hand with regards to the shoreline ordinances, we have to evaluate, do we have a concise written statement indicating what relief is requested and why it should be granted?
Well, I think it's
I
very,
believe that
it's looking for, yes. I think that's just decisive.
Pete, did you have anything further?
I guess based on your explanation that, yeah, this gives us the ability to move forward.
Okay, so the motion is to deny the town's request of Attorney Wagner, how did we word that?
The motion to deny the town's request for dismissal of violations 1, 3, 5, 6, 9, and 10 is, so I move to deny the town's request to dismiss violations 1, 3, 5, 6, 9, and 10 on the grounds that they are not, do not comply with the section
Yeah.
16 G3A2I.
Yeah, thank you. So that is what's on, that's the motion. So all those in favor of denying, David Marsh, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay.
Okay. So are there any further procedural motions from the parties?
Not from the town.
On behalf of the appellant, two points. First is I have a concern, and I'd like to place it on the record as it relates, I guess, to the integrity of the process, wherein it appears that the board has found this application complete and made factual findings related to its contents, when in fact it was then found to be that two of the board members didn't even have the relevant application before them and hadn't even had an opportunity to review it. To me, that rises or creates a concern as to the integrity of this process and to the decisions that the board has reached to this point, let alone what it might find after this. And so I'd like to raise that. I mean, it's important, not just for us in our case, but also, potential appeals by the town if and when they want to claim that the application was incomplete or speak to the process and the findings from this board. The second is generally, I'd like to make an ongoing objection to this process and the hearing of these violations as being a due process violation against Big Lake Marine LLC. And specifically, every one of these violations that is set forth in this notice is a carbon copy, literally a carbon copy, identical in language to every single other violation that has already been heard by this board. And so the chair, to his point, indicated that there wasn't much detail here and he would rely on or hope that I might present some evidence in support of our appeal and in objection to what the town has alleged. The fact is, this board has already made findings of fact as it relates to every single one of these violations. When we look down through these, we've had hours, in fact, already of testimony and facts presented to this board for which Big Lake Marine was not a party to that hearing and could not participate or present evidence or speak to those. And so we're now in a position where the board either has to find exactly the way it's already found related to the facts alleged in these violations, right? Or it has to find something that is contradictory to what it has already established as far as the facts in the management control and Q team appeals that have already been determined. And so I would like to bring those 2 points up, and again, make the request that this notice of violation against Big Lake Marine be dismissed or abandoned by the town.
Chairman, can I say something?
Well, I think you should let Attorney Wyckoff respond, and then we can open it up to the board.
So first, as to whether there is an issue as to the integrity of the process, you know, I don't think there is an issue with the integrity of the process. However, if the board wants to, you know, is concerned that there's an issue there, then the board should ratify the decisions that's already made after, you know, and it's clear that the 2 members of the board, that they've all looked at the application, whatnot. So if to the extent there is any issue, and I'm not saying there is an issue, but if there is an issue, it can be cured simply, I think, by the board ratifying the determinations they already made with regards to this application. And then as to the due process, the allegation that there's a due process violation, what I heard Attorney Braun say is that all of these violations are carbon copies of the violations that have been heard by the board. And he expressed concern that the chair said, made a reference to Attorney Braun providing information to help with regards to this appeal. And he expressed a concern, well, that the board's already made findings of fact and had some concern there. Well, I think that's a mischaracterization of what the chair's comments were. I think what he was referring to was responding to my contention that the application was insufficient because it didn't provide a statement of why the appeal should be granted, and that there was the chair saying he thought was hopeful that Attorney Braun would help them to understand the basis that the Big Lake was bringing this appeal. Now, if Big Lake wants to rest on the testimony and evidence that's already been provided, that's fine with the town. We're happy, that's fine. In the town, we can provide, evidence in response to what's already been presented. And that record is all open before this board still now. And like I said, if Big Lake wants to rely and rest upon what's already been presented, that's fine with the town. I'm happy to do that. And then we'll continue on with the evidence that we're going to put on relating to these violations. Now, as to, it's not clear to me whether or not Attorney Braun is making some argument relating to this appeal in connection with the determination by this board that the Duran Excavating appeal was untimely. And I just want to address that squarely. So the board didn't reach any of the substance relating to Duran Excavating's appeal. The decision was determined that it essentially didn't have jurisdiction because the appeals were untimely. So there aren't any findings that have been made there. So there isn't any issue with regards to that and this appeal going forward relating to the notice of violation that was served on Big Lake. Thank you.
So before I turn it over to the board, Mr. Chair, if you don't mind, if I just weigh in here. So I pretty much agree with just about everything that Attorney Wyckoff said. I think the objections are noted, and the board should, either overrule or grant the objection, but I'm not even clear what the relief is that's being requested. I think it's essentially to, but candidly, I'm not entirely sure, so I would defer to Attorney Braun after I'm done speaking if he wants to clarify what the relief is that he's procedurally requesting. But in my opinion, there's not an issue with the integrity of the process, but you know what, my job as the town attorney is to, protect whatever decision you make from appeals. So I do suggest you go ahead and ratify all your prior decisions concerning jurisdiction and standing, and I can walk you through the motion to do that, having now confirmed that all the board members have identified and read the notice of appeal. I don't have anything to add except to say that I agree with the, I'm not sure how the argument that these are carbon copies is a grounds for that the appeal should be granted at the outset. I think we could, you know, to the extent that there's an argument similar to what the other party made that these are duplicative, that's certainly an argument that can be made, and the board should address it as well. But I think that there's a, you know, the prior appeals we've had, that was an entirely different party. In fact, a different party. So I think it's a separate factual question. So the board does need to make separate factual findings as to whether this party committed the conduct in the notice of violations. Now, I think Attorney Duran raises some good points of, you know, some of those findings. It may be logically impossible for the board to find one way on management controls and the other way on Big Lake Marine. But we can address that as we get into the substance. I don't think that's a ground for at the outset granting the appeal. And I also agree in terms of the applicability of the decision made on the Duran appeals that that was not on the substance, so there are no factual findings. So with that, that was a long interruption to your question, Fred.
No, I was just gonna bring to a point again, with all the paperwork we have for all this that's going on here. And when David asked me, I'm trying to find it. I do have this and have looked at it, but at the time, when you're trying to find something in a hurry, you can't necessarily always put your finger onto it. And then once, I saw what I was looking for, it was quick and easy for me to be able to dig through the paperwork while you guys were all talking, and I did find that I did have this. Just wanted to bring that up.
Attorney Braun, did you have anything further you wanted to state?
I mean, again, my primary concern and argument here is that Big Lake Marine has denied a fair opportunity at a hearing as it relates to the facts outlined in the violations, specifically because there has already been so much evidence entered relates to the factual circumstances at issue. And the board has already found and established findings of fact as it relates to all of these issues and instances. And Big Lake Marine was not a party to those hearings and was not given opportunity to argue against or on behalf of those findings of fact.
So I'm going to just for the record make clear that I disagree with that characterization. I think that the sequence of presentations laid out in each one was clear that you had an opportunity as a member of the public, even though you weren't a party, to ask questions, to weigh in. You could have you could have made arguments, and I think that the record reflects that opportunity was given to you. So I would challenge that characterization, but appreciate the clarification on that, and I would suggest to you, to the chair, members of the board, that you have an objection to, I think, essentially continuing the appeal on the basis that you have not given appellant a adequate public hearing consistent with their due process rights. So your choices are to overrule that appeal, in which case that would be noted for the record, and that's certainly an issue that Attorney Braun can raise before court, and he's preserved it, or you could grant that objection, sustain it, as we would call it. So I'll turn it to you, Mr. Chair.
Yeah, it's not clear to me where the insufficiency is. Is it in regards to the determination of applicable filing time? Is it in determination of the appeal being complete, or is it in reference to the ability to present information specific to Big Lake Marine in regards to these notice of violation. Well, in regards to these violations, just want to be clear which of those three or all three is Attorney Braun contending.
I mean, sure, all three. Although you mentioned timeliness, so I don't think that's relevant. The point is, first and foremost, is that there are notice of violations that at this point have been upheld against Duran Excavating LLC related to exactly the violations that are before the board now. And given the fact that this board has denied those appeals and essentially upheld the notice of violations against Durant Excavating LLC, this appeal, or excuse me, this notice of violation against Big Lake Marine should be denied. The second is the argument that there has been an administrative due process violation in that, despite Attorney Wagner's position that as a member of the public, we had opportunity to give some comment, we in fact were not a party to any of the prior hearings that took place. And these violations are carbon copies of each other. And this board has essentially already reached a decision as it relates to all of the factual or facts outlined and alleged in these violations. To which, if you were to look at Management Control LLC's notice of violation dated January 28th, 2022, and look at that of Big Lake Marine LLC dated March 10th of 2022, you'll find as you go through every single one is exactly the same. And you've already made decisions as it related to what that conduct was. And to the extent then that Big Lake Marine I don't see how we have opportunity to in any way sway what the decision might be as it relates to any of those violations.
So I will say our board members recognize that each case or each appeal brought before us is its own unique, distinct case. Our decisions made on the previous cases were based on information provided by the appellant. It was not, that's how those decisions were made. I am ready to go into this appeal, ready to listen to the information you have. That's what I want. We want to be able to listen to this. We want to be able to take Rob Durant's concerns and make a finding on it based on that information, not the information that was provided to us previously by other appellants. We want to hear the information provided by this appellant. And we recognize that each case is specific to itself.
But the problem with that is that we have relied, or this board has relied on prior evidence and information that's been provided to it in those prior hearings. You did so for Management Control, and you did so as it related to Q Team.
Those are both represented by the same person.
If I may interject, just as a reminder, when this all started, all the parties agreed that the appeal, that the record here for all of these appeals could be considered for each other appeal. The parties all agreed to that. I just want to point that out.
I would not mirror or echo that sentiment. In fact, I don't recall being a party to that decision. I do recall that being discussed and considered when Attorney Rachin began her initial presentation. But again, that was not a specific hearing that I was or Durant Excavating or Big Lake Marine were party to. Rather, we were merely, as Attorney Wagner pointed out, a member of the public here to watch and observe.
Well, the record will speak for itself.
And thus I've asked to preserve any rights of appeal as it relates to administrative due process.
Well, I want to move forward one way or the other, so Attorney Wagner can just guide us through.
Make a motion to overrule the objections of Attorney Braun and requests to, as he phrases it, deny the violations.
So moved. Do we have a second?
I'll second that.
Any further discussion? So all those in favor of denying, David Mertz, yes.
Vanilla, yes.
Lockwood, yes.
Okay.
So I would also suggest that the board make a motion to ratify all of its prior findings concerning standing, jurisdiction, and timeliness based on its further review of the record materials.
So moved. Do I have a second?
Second.
Any discussion? All those in favor of ratifying, David Murch, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. So we are over 2 hours into our meeting. I would like to propose a brief 5-minute recess just to make use of facilities, get something to drink. Does that sound okay with everyone?
Yes.
Okay, I show on my clock 8:13, reconvene at 8:18. Okay, so resuming our discussion on Big Lake Marine, specifically administrative appeal, read notice violation issue 310/2022, location 18 Farmwood Road. Attorney Wagner, if you can just sort of direct us through the next step.
Unless there are any further procedural objections or issues from the parties, not
Nothing
seeing-
from the town.
Okay. Any other attorneys on the line? Any procedural questions? Leah, I'm looking at you. No. Okay. Then we start with the sequence presentations from the appellant. So Attorney Braun, without interruption, followed by questions from the board to Attorney Braun, and then I'll turn it over to questions from the town to any of the witnesses that Attorney Braun puts on.
All right, thank you. Well, so Greg Braun on behalf of Big Lake Marine LLC, managed and sole member being Rob Duran, here in appeal of the notice of violation dated March 10th, 2022, related to actions that were alleged to have taken place at 18 Fernwood Road in the town of Raymond. I have before me an 11 count notice of violation that in almost all regards is a carbon copy of the allegations, the notice of violations that were issued to Management Controls LLC on January 28th, 2022, and substantially to the extent that the violations were included, exactly the same as the notice of violation that was issued to Q Team related to the same property as well. This board, from my perspective, has already made findings of fact as it relates to each one of these allegations and the factual basis behind it. But for, or to the extent that Big Lake Marine LLC was involved. To wit, I will draw the board's attention to alleged violation number 1, the filling and earth moving of more than 10 cubic yards. And this is alleged to be a violation of section 15, subsection U1 of the town of Raymond Shoreline zoning provision. And a quick look back at the January 28th, 2022 notice of violation against Management Control LLC will show that the language mirrors it absolutely almost identical. And I will say again that this board has already established from those prior hearings that it believes this violation took place. And to that end, I would preserve any right of appeal as it relates to that decision and argue that Big Lake Marine LLC was not given sufficient opportunity to participate in that hearing and decision. The truth remains, though, as it relates to this work and to this violation, that any work that was done with the intent and idea of soil erosion prevention. That the work done on this property was done related to an ongoing problem where sediment was running off of the lake or running off of the shore and into the lake, thus resulting in a obvious and significant reduction in the lot size of this property in question. The specific argument here is that the contractor failed to both properly obtain the permits and do the work without using the proper tarping or necessary provisions to maintain the integrity of the slope or to keep sediment from running off into the lake. And I would argue that based on the pictures that were provided and the evidence which this board has already considered and ruled upon, that just is not the case. In fact, everything we've seen indicates that the contractors in this case used hay bales, they used black tarps, and they did what was necessary to preserve the shoreline. And in fact, many of the photos that were provided to this board when it made these determinations were months old and after the job had been abandoned based on the request of the town to cease work. Turning to violation alleged to be number 2, the filling and earth moving without a permit, as has previously been argued, and we will echo here. And again, note that the board has already made a decision as it relates to these facts. It's duplicative of the first allegation. Essentially what we've done is we've charged or alleged that the conduct itself was a violation and then the permitting or failure to permit itself was a second. When in fact we argue, as has been previously argued, that that should be one in the same as it relates to violations. Notice of violation number 3, illegal shoreline access, has alleged that a second set of stairs to access the water was added without a permit. Now, the respondent, the appellant here, objects to that allegation. It would note that in all of the pictures that it has seen and have been presented to this board, noting again that this board has already made a determination as it relates to this alleged violation, clearly demonstrate that there were 2 sets of stairs that already existed, and that there wasn't, in fact, any second set installed, and certainly nothing done by the appellant here. Notice of violation number 4 alleges that a pier, dock, wharf, bridge, boat launch, or other structure and uses extending over and below the normal high water mark or within a wetland without a permit was established or created. Here too, as has been previously argued and as the board found to be the case here, or I should say it's already ruled as it relates to the allegation of a violation. There were no new docks, wharves, bridges, boat launches, or other structures installed. Rather, what took place was basic repair and maintenance. It was not new work or new structures, but anything that was there was actually already pre-existing. And the only work that took place as it related to these allegations of structures was in the form of maintenance and repair. Essentially picking up rocks, putting them back where they originally belonged, but not actually the installation or creation of any new piers, docks, wharves, bridges, boat launches, or other structures. And this brings me into point 5, which, looking just at the clear language of the alleged violation, makes me scratch my head a little bit. Now, again, I'm under the understanding, I stand to be corrected, but that the board has already established this violation took place without Big Lake Marine having opportunity to participate in that hearing. But what is alleged is that the shoreline itself has been enlarged. I don't see shoreline itself being listed in the specific ordinance here as something that is relevant to section 14, subsection 17B. We speak to piers, we speak to docks, we speak to wharves, we speak to bridges, we speak to boat launches, and we speak to other structures. But a shoreline is actually the circumstance or boundary at which the water reaches the land. It is not itself a structure. And so for the town to allege that the shoreline has in some way been extended or increased is unclear. There's just as much water front footage as there was before. And in no instance does any of that constitute a structure. Notice the violation 6, construction of a beach without a permit. As this board will recall, it considered at length what the definition of a beach was. We went to Merriam-Webster's dictionary, I believe, and this board already established that it felt this violation had occurred without Big Lake Marine having an opportunity to participate in that hearing. We would argue that that is not the case. And in fact, what was alleged to be a beach or found by this board to be a beach was in fact nothing more than the way the rocks looked at the time that those specific pictures were taken, and that the characteristics of the shoreline changed depending on the height or depth of the lake, depending on the season. Alleged violation number 7, the removal of vegetation less than 3 feet in height. We would argue that that is not in fact true. I believe that the town dismissed this as it related to Q-Team previously. I don't know if that's because it intended to maintain this allegation against Big Lake Marine or Durant, but I do know that this allegation was previously dismissed or abandoned by the town as it related to other alleged violators. We would echo and continue to maintain that no vegetation less than 3 feet was removed. Rather, it was merely trimmed. That it was cut in such a way as to manicure or tame it, but that it was not in fact removed. We would argue that violation number 8, which alleges this behavior without a permit to be a second or separate violation, is again duplicative, that we're looking to count the same conduct as a violation twice, when in fact it should be just considered once. And we make the same arguments as it relates to number 9, being the unpermitted shoreline stabilization without a permit, and the unpermitted shoreline stabilization using a barge rather than from land. Finally, and most specifically and obvious, is a denial of any allegation that Big Lake Marine or any other entity owned or operated by Rob Durant cut any trees within 100 feet of Sebago Lake. Again, this board has already established through its prior hearings that the Q-Team committed this violation. They were hired to do that work. That's been explicitly stated in the past. And so we would object and deny to that allegation.
Thank you, Attorney Braun. Is that it for now?
Yes, sir.
Okay. Attorney Wyckoff?
Yes, thank you. Okay. So I'm going to share my screen. Actually, I'm not going to share my screen yet. What I have a question for the Mr. Chairman. You know, when we did this in prior presentations, we began by having Alex Roy kind of walk us through the background of the facts here. I know we did that previously with regards to Fernwood, but I'm wondering, given the passage of time, if the board would like to have Alex do that again to remind them of what the facts are that we're talking about.
I would like that. Pete, Fred, though, what are your thoughts?
I think I'd like to see it.
Pete, can't hear you. Yeah, mute.
Yes, I would agree that that would be worthwhile.
Okay, so what I'm going to do is I'm going to turn it over to Alex to have him go through his Google slide presentation regarding the property. And then after he does that, then I'll go through and I'm happy to address each of the violations that Attorney Braun just was addressing.
All right. So here we go again. I'm going to pull up the slideshow. This is all same as before, so shouldn't be any new information in here. But we'll go through, you know, just some of the history. Obviously, like we discussed before, you know, the town was notified of the activity on site by Maine DEP. Field agent was actually out on the lake. We also received a call later that afternoon from the fire department as well, you know, out on the lake, and she sent in this photo, basically said, you know, this work's taken place. Do you have any record of a permit in the file? We did some research and found that we did not have a permit in the file or a pending permit for any activity on this particular property. We did a site inspection with DEP, Rob Duran, and Portland Water District that October, and these were the conditions that we found the property, you know, a week or so later. So going through the violations, the first one is filling an earth moving of more than 10 cubic yards. Just to put it into perspective, the average dump truck is 10 cubic yards. So if you, you know, looking back at some of these pictures, all of this rock was not on site. It was all brought in. You can tell just by this one picture that there's more than one dump truck of rock that was, you know, brought into the site. That's pretty easy to determine off of that. You know, all of the shorefront was regraded. There was numerous stumps that existed all along this that were pulled out, and you know, the shorefront was reshaped and sloped, and you know, they clearly exceeded more than you know, 10 cubic yards of disturbance. There was no erosion control plan filed with the town, and as you can see, there's actually, you know, there is a silt fence, I guess you could say, installed that's actually falling down in numerous different spots. There's also a berm of mulch at the top of the hill and spread out all over the property. I'm not sure if this is actually an erosion control mix. It looks more like an ornamental mulch. I don't know that we've ever really gotten any you know, concrete evidence that that's actually an erosion control mulch. You need to use stump grindings because it actually you know, is waterlogged and you know, won't just float away during a storm. So this fill was just deposited in spots. The shoreline was natural at one point, obviously, and it kind of, you know, ebbed and flowed in and out. And that shorefront is now linear. It's basically a straight line across. All of this work would have required a permit from the town and an erosion control plan. And like I said, neither of those were things that we had. So the next one would be the stairs. There was an existing set of stairs, granite stairs. You're allowed a single 4-foot wide set of stairs to access the water. This photo that was taken prior to the work being done, actually in August of 2021, does show a second set of stairs. And Attorney Braun did mention this. There is no permit in the file for that second set of stairs, so they may have existed prior to the work taking place. What it really comes down to is that second set is not legal. There's no permit in the file for that. You can see that there. And there's the after photo, which shows they still have that original set. They have the second portable set, and then they actually increased the length, you know, adding risers. I believe that's more granite that they brought in. And that's the actual, you know, the violation there. They've made that second set larger. So this next one here is on the jetty, which we are going to bypass for now. And so in this next one, we have, well, I'm actually going to go back. Sorry, I'm going the wrong way. There we go. This would have been the shoreline stabilization. And you can see, oops, sorry, here, if you look at the stairs, the granite stairway, for example, you can see there's a couple of large stumps, rocks, some shrubs. This shoreline goes in and out. And I like to point to the, I'm actually going to circle it so it's easier. That's okay here. If I can. Oh, it's black, so that's not going to help. I'm going to circle it a few times. This section right here, if you can see that, you'll see that next to that rock and the stump, the water actually jets in. And if I go to the next, clear, just going to turn that off. If I go to the next slide, oh, that's not a good photo of it. Here, I'll go to this one. I guess I don't have one showing that section in this right here. If you look at the stairs again, you can see that the rocks have filled in the area where the water previously, cut in. That's been done in a few different spots along the shorefront, filling in areas that were natural. You can actually see how much lower that rock is now compared to what it was before. Okay, going back here to the beach, I'd like you to look at the water itself, not the shore where the rocks are. But if you look into the water, you see a lot of large boulders, a lot of mixed size rocks. It's not just all small rocks or large rocks. There's a little bit of everything. In this next photo, you can see a strip right down the middle where, the photo before, it looked more like the rocks you see on the right-hand side. Mixed size is a lot of large boulders. And then you've got this section in the middle now where it looks as though the large, medium-sized rocks have been removed, exposing just the sand bed, creating a beach area where if you come down those stairs, now you can go to this nice little beach area later in the season when the water level gets lower. So I think, looking at this photo, you don't see that area where there's less rock. You don't see any exposed sand here. That's really one thing that DEP was really urging us to, to hold on to because they thought that was pretty significant. So next we're going to go to the tree removal for vegetation less than 3 feet in height. Vegetation has been removed entirely or trimmed in basically this whole 100-foot section of the shorefront. You can see right here all of this natural, there's some saplings, but it's a lot of just, smaller ground cover, bushes, shrubs, gone, all completely gone. You're not allowed to remove anything less than 3 feet in height within 100 feet from the water unless you're, doing it as part of an approved permitted activity. You can see up here on the hill behind between the rock and the playground equipment, there has been some removal of the small vegetation as well. If you look in the upper left-hand corner of this photo, you can see it growing on the ground. In this photo here, it looks like there's a good portion of it's been removed. All the way up to the back of the hill where they removed a few small ornamental and stormwater retention ponds. Moving on to the other side, kind of the same deal. You've got a lot of ground cover looking above the shorefront to the tree area. You can see there's some large bushes growing there and some ground cover, natural ground cover, packed pine needles, leaf litter, all gone. That's all been removed. Again, can't remove anything less than 3 feet in height within 100 feet or trim. You can't trim it, you can't prune it so that, it's not vertically growing. It's a big question we get a lot. People, down near the shorefront, their bushes, shrubs are getting 5-6 feet tall and they're scared they're losing their view. They want to trim them. You actually can't do that. Can't prune it for, that vertical height. Next is the hot tub. We're going to bypass that. And come up to the stabilization, done from land or versus the barge. Rob Duran does have access to a barge. I believe he's one of 2 companies on the lake that has, actively doing some work from a barge. He does use it frequently. This was actually the barge moored in, just around the corner in a different cove in November of 2021. You know, the whole goal of this is to see these types of stabilization projects take place from the barge so that the excavator is not having to come through the woods down the hill and, you know, disturb all of that shorefront. The work was not done from the barge. It was all done from the shore. And then the last one here is tree removal within 100 feet of Sebago Lake. You know, there's been at least on this lot, I believe 16, I think, trees that we identify that have been removed as part of this project. Those ones are all gone. And by doing that, you know, they've created an illegal opening in excess of 250 square feet, which is the limit by the ordinance. You can see here, these two areas have been opened up, and you know, it's approximately 60 by 120, so it exceeds the 250. We assume we approximate on the measurement of 60 by 20. There's 3 grids we can see that have been affected by this tree removal on the front lawn, exceeding what's allowed by the point system for selective removal as well. I believe that is it for the slideshow.
Thank you, Alex.
Thank you, Alex. Appreciate that. So now what I'm going to do is I'm going to share my screen and share my PowerPoint presentation, and Alex and I are going to go through it together. I'll address the, I'll address the things from a legal perspective, and then if, to the extent there's any factual information we need, I'm going to ask Alex to provide that to us. Okay, so just want to start with violation number 1. So first, for all of the reasons that you upheld violation 1 and the notice of violation to management control related to Fernwood, you should uphold this violation as to Big Lake as well. So violation 1 relates to filling and earth moving that occurs in violation of the shoreline zoning ordinance. And the ordinance requires that that activity is done in a way to prevent erosion and sedimentation of surface waters, and requires that if permits required, then the activity must be done in accordance with an erosion and sedimentation control plan. So as Alex testified earlier, more than 10 cubic yards of filling and earth moving occurred. And Alex, can you just describe, when that much earth moving occurs, what's needed?
You need to have an erosion and sedimentation control plan in place, and then they also need to have, that effective erosion and sedimentation control on site and effective. They also need to be a DEP certified contractor. Okay.
And here, did they have a permit from you?
They did not.
And did they submit a erosion and sedimentation control plan?
They did not.
Okay, I'm gonna share my screen and I'm gonna go to the notice of violation and go to page 6. Can you describe what we're seeing in this photo with regards to erosion and sedimentation issues?
Yeah, an attempt has been made to have an erosion control installed on the site. You can see there's a silt fence all along the entire bottom stretch, the downhill side, of the shorefront. But you can also see that it actually is falling over, and in places in the bottom is actually blowing around. So it's clear that it's supposed to look like it's up. If you're passing by in a boat, you might think it's doing its job, but once you actually look closer, you'll see that it's really not doing anything and wouldn't be considered an effective management of the stormwater erosion on site.
And over here, is this the area you're talking about where the fence is falling over?
Yeah, it looks like it's falling over there. And then, on the right-hand side, you can see it is also falling over, very loose over those rocks. It's supposed to be keyed in on the bottom to prevent any, phosphorus, any runoff coming through the bottom of that. You can see there's bare soil exposed at the top of the hill. If there was a significant October storm like we usually get, it's going to be running right down that hill underneath that loose fence into the lake.
Okay. And what is this photo showing here with regards to sedimentation and erosion control?
Yeah, a little bit of the same. Actually, you can see here in this one, it's actually completely down on the left side there.
Okay. Same thing here.
Yep, same thing there.
And same thing in this picture too.
Yep.
Okay. Okay. And so that's violation number one. Violation number two. Violation number two is for filling and earth moving of more than 10 cubic yards without a permit. And so, you know, the ordinance provides that whenever you got more than 10 cubic yards of filling and earth moving, then a permit from the CEO is required. Alex, did you have a permit for this filling and earth moving work?
We did not.
Okay. Big Lake contends that violation number two is duplicative of violation number one. I just want to address that. You should reject that argument just as you rejected it in connection with management controls, similar arguments relating to violations 1 and 2 and the notice of violation to management controls. Here, with regards to Big Lake, violations 1 and 2 are separate violations. Violation 1 is for filling and earth moving being done without taking steps to prevent erosion or sedimentation. And as Alex just described, that occurred here. Violation 2 is for filling and earth moving without a permit. So even if you have a permit for the filling and earth moving, there would still be a violation here because of the failure to take steps to prevent erosion and sedimentation. And likewise, if steps had been taken to prevent erosion and sedimentation, there would still be a violation because the work was done without a permit. So violation 1 and violation 2, they're not duplicative, they're separate violations. Okay, violation number 3. Violation 3 is for providing illegal access to the shoreline. So stairs to provide access to the shore are permitted with a permit from the code enforcement officer. And here, as Alex testified earlier, there was a new stairway that was added, and there was no permit for it. Okay, violation 4 related to the jetty. The town withdraws violation number 4. Violation number 5. Violation number 5 is for enlargement or expansion of the shore. And for the same reasons that the Zoning Board of Appeals upheld a violation 5 in the notice of violation to management controls for Fernwood, you should do the same thing here and you should uphold this violation. So in section 14, line 17B, that's the table of land uses. It requires that permanent structures and uses extending over or below the normal high water line require approval from the planning board. Now, Alex, can you talk this through for us and walk us through this violation?
Yeah, what this is the one that I had kind of spent some time on a few minutes ago, which was about the shape of the shoreline. If you look at that, it's a little bit easier to look at it and think about the shape of it. You know, before there was some large boulders, some shrubs, some old stumps. It was naturally occurring and it kind of ebbed and flowed, jogged in and out. What now exists is a straight rock line. So there has been some modification of that shorefront in areas where there was once water is now, you know, rock that's a few feet higher in spots. So that activity is not something that can be just done, you know, without you know, going through the process to obtain approvals first.
Thanks, Alex. Next is violation number 6. Violation number 6 is for construction of a beach without a permit. Now, the same reasons you upheld violation 6 in the notice of violation to management controls, you should also uphold this violation. the shoreline zoning ordinance at section 15.0 requires beach construction to be done without a permit. That provides, it requires it to be done with a permit from the DEP. You know, as we've talked about before in the prior hearings, beaches can be composed of stones and rocks. And when you look at the dictionary definition of what a beach is, it's that a shore of a body of water covered by sand, gravel, or larger rock fragments. I think Mainers understand that a beach can be made of stones and rocks. And as Alex testified earlier when he showed you photos of the before and after, it's pretty clear that the beach area has been pretty significantly expanded as compared to before. And Alex, are you aware of there being a permit from the DEP to do that work?
There was no permit from DEP to do that work, no.
Okay. And was there a permit from, and you didn't issue any permit, so there's no permit from
Nope.
the town or from the DEP?
Correct.
Okay. Okay, exhibit number 7, violation number 7 is removal of vegetation less than 3 feet in height. So for the same reasons that you upheld violation 7 and the notice violation to management controls, you should also uphold this violation here. The shoreline zoning ordinance prohibits the clearing or removal of vegetation under 3 feet high within 100 feet of the normal high water line. So Alex, I'm just going to go to the notice of violation and just ask you to walk us through this
Sure.
violation.
Yeah. I mean, I think this is one of the most drastic changes you'll see for all of the photos, the before and after on this one here. I mean, you see the green shorefront, natural green shorefront. And then the after photo, you see all of that vegetation less than 3 feet in height has been completely removed, and that's well over 100 feet right there. That carried all the way back up the hill in that before photo, as you see. And they did the same on the other side of the property as well here. And if you look at that dashed white line, you'll see that area, everything, all the ground cover has been completely removed. So, now if you stand at the top of the hill, in front of the garage, I mean, you've got a clear shot right down to the water. Where before it was, a natural forest, a natural wood area.
Now, Big Lake contends it just trimmed the vegetation. Is trimming a distinction that makes a difference?
I mean, you're still removing. I mean, if you're going to trim down to the ground, that would be considered removal. You can't prevent vertical growth of vegetation less than 3 feet in height. It's really going to come down to the same thing, and that's probably going to kill it. It'll grow back eventually if you will let it. But what we find is in most cases, people will trim it down and then they'll mow it like lawn and it never comes back up.
Okay. Violation 8. Violation 8 is for removal of vegetation less than 3 feet in height without a permit. It's for the same reasons that you upheld this violation as to management controls. You should also uphold it with regards to Big Lake. Now, the shoreline zoning ordinance prohibits clearing or removal of vegetation of any height without a permit. Now, Alex just described how there was vegetation removed. Was there a permit that had been issued relating to the removal of the vegetation, Alex?
No.
Okay. So the work was done without a permit.
Yes, correct.
Big Lake contends that violation 8 is duplicative of violation number 7. So violation, as I described a moment ago, violation 7 is for clearing or removal of vegetation less than 3 feet in height within 100 feet of the normal high water line. Violation 8 is for clearing or removing vegetation of any height without a permit. So they're separate violations here. Here we have violation being removed within 100 feet of the normal high water line, and also vegetation being removed without a permit. So you should reject this argument just as you rejected it in connection with management controls, similar arguments as to violations 7 and 8 in the notice of violation to it. violation number 9 is for an unpermitted shoreline stabilization project without a permit. So shoreline zoning ordinance requires that a stabilization project must have a permit from the planning board. And here, that's what Big Lake Marine contends it did. It contends it did a stabilization project. And Alex, was there any permit for that?
Nope.
Okay. Violation number 10 is for the unpermitted shoreline stabilization without a barge. And for the same reasons that you upheld violation 12 in the notice of violation to management controls, you should also uphold this violation here. So the shoreline zoning ordinance requires that any stabilization project must have a permit from the planning board, and that construction equipment must access the shoreline by barge when feasible, as determined by the planning board. Now, Alex, did you determine whether it was feasible to use a barge?
Yes.
Okay. And here, a barge wasn't used?
Barge was not used.
Okay. So therefore, then there's a violation here because the project occurred without a barge. Okay. The next violation, it relates to the removal of trees within 100 feet of the shoreline without a permit, and the town withdraws that violation as to Big Lake. I don't have anything further. Thank you. Oh, you're muted, Chairman Murch.
I see that. Attorney Braun, do you have anything you'd like to?
Oh, actually, excuse me. I misspoke. There's something else I did need to address that I didn't address. I apologize.
Sure.
So Big Lake argues that the work that it performed met the requirements for permit by rule under the DEP's protection rules for shoreline stabilization, and also that it complied with the town of Raymond shoreline zoning provisions. Let me just address the last part first. I think it's pretty clear, based on what you've heard here tonight, that the shoreline zoning ordinance for the town was violated. So most assuredly, that's just not the case. Now, the work also didn't meet the requirements for a permit by rule under the DEP rules. A permit by rule is only permissible for up to 100 feet of riprap on an eroding shoreline. And here, there was riprap installed along 400 linear feet. So the DEP found a violation, and in fact, we've provided you with a copy of the DEP notice of violation. It issued a notice of violation to Mr. Buteau and to Mr. Durant of Big Lake Marine. And here's a copy of the notice of violation. And then if you go to page 4 of it, the DEP noted here that I'm wrong. On page 3 of 5 here, the DEP noted that by installing the riprap in areas where vegetation was already established, 8 feet above the normal high water line, on slopes that are less than 33%, and on slopes that are steeper than 1-to-1, without first anchoring at the base of the existing bank or pinning to ledge, without first placing crushed stone over a layer of filter fabric, and by placing fill material other than riprap below the normal high water line, therefore failing to construct this riprap project in accordance with the plans submitted pursuant to subsections B3 of this subsection. In other words, Big Lake did not comply with the permit by rule requirements. So this argument should also be rejected. Thank you. I don't have anything else.
Thank you. Attorney Braun?
Yeah, sure. So the first thing I would point out and continue to impress upon the board here are Attorney Wyckoff in the town statements that, as you previously found, I think stated for every single one of these notices, again and again, to the point where obviously the presentation is almost identical. The arguments are certainly exactly the same. And they're asking you essentially to find just the way you already have, in most cases, twice before. And to that end, again, I'd like to preserve any rights of appeal as it relates to due process violations or a failure to provide us a fair opportunity to participate in this hearing. Specifically, I would reply to Attorney Wyckoff and the town on just a couple of points. The first is as it relates to violation number 1. Again, this allegation that steps were not taken to protect the shoreline or to diminish what might have been sedimentary runoff into the lake while the job was being performed. Clearly, all of the necessary materials were there. Again, we looked at the black tarps. We were shown that. We were shown the hay bales. Things and steps were taken. What isn't clear is when those specific pictures referenced by the town were taken. I would note that there seems to be some inconsistency in the pictures, and that some show a very high water level and some show a very low water level, right? And again, that what we're talking about is a job site that was abandoned, right? And a place where those measures and materials which were in place essentially were left to be neglected because the cease work order was put in place, and neither the property owner nor any of the contractors could go back out there to either reinforce those materials and protections, or otherwise maintain what was already in place. And so again, so that would be a further argument in response as it relates to that violation number 1. In response to violation number 3, and again, Attorney Wyckoff and the town point out that you've already ruled and found a certain fact to be true here. I would note that Alex acknowledges that second set of steps already existed. All right. And so when we talk about this, there is a distinction between the addition, right, of a second set of steps and the repair and maintenance of a structure that might already exist. So it may or may not be true that a permit was not originally obtained for that second set of steps. But as Alex indicates here, it existed when this work was performed. And so there was no addition of that second set of steps as it relates to number 3, but rather a repair and maintenance of a structure that already exists. I would then draw your attention again specifically to this alleged violation number 5. And again, where it seems to me we're trying to shoehorn one alleged act into multiple violations. It's one thing if we want to say the shoreline itself is a beach. As Attorney Wyckoff pointed out, we live in Maine. Sometimes beaches have rocks, right? They come in different characteristics. It's another thing to call a shoreline or a beach a pier, dock, wharf, bridge, or other structure which extends over and above the normal high water mark. I would argue that the work done here and the stones that the town makes reference to cannot constitute both a structure and a beach. It is either number 5 or number 6, but it cannot be both. And in this instance, again, as Attorney Wyckoff points out, you've already made findings of fact as it relates to these allegations. But I think it's clear that a shoreline and the shoreline itself is not what's contemplated in that violation number 5, which is the section 14, subsection 17B. If we want to talk about modifications to the shoreline or the construction of a beach, that being the allegation of number 6, then potentially someone could argue it falls into that category, but it doesn't qualify or fall into both. And with that, I don't have any other specific responses to be made. I would otherwise just rely on the arguments that have already been presented.
Mr. Chairman, do you want me to respond? You're muted, sir.
I see that. Yeah, please go ahead.
Okay. I'm going to share my screen. Alex, I want you to look at Exhibit A here. And this shows the shows the silt fence and the erosion control measure that was supposedly taken. When was this photo taken?
Yeah, this was taken in October during construction.
Okay, so this is when construction was taking place, when Big Lake was on the site doing the work.
Yep.
Okay. Thanks very much.
Yep.
I just also want to address this contention. I think I heard Attorney Braun saying that violations 5 and 6 are the same thing. So violation 5 is for enlargement or expansion of the shoreline. And violation 6 is for construction of a beach. Those are different things. Alex, can you describe, are these different locations on the shoreline that we're talking about here? Along the property?
You're talking about the beach and the riprap work? Is that what you're?
Exactly.
Yeah. So the way DEP has always instructed the towns to handle, the shorefront retaining walls is to treat them as a structure. A beach is not a structure. And in this case, we aren't calling the beach a structure. We're calling it a beach. But the actual rock that is being used to stabilize the shorefront, is considered, something that requires that approval because it's not something that is just typically allowed on any site. You need to have a specific reason for it.
Okay. I'm going to share my screen for a moment here. Okay. I'm on Exhibit C to the notice of violation, Alex, and I want to focus on the bottom photograph.
Mm-hmm.
Now, the area in which the beach has been constructed,
Yep.
Isn't that the portion of it that's on the right-hand side of the photograph?
Yeah, and I, like I said before in the presentation, look at the before photo, which was taken. Yes, it was taken, probably a month and a half or so earlier. But you can't see any, you don't see sand bottom in that. It's all rocks,
Right.
large boulders.
So I'm trying to make a geographic location of the face of the earth distinction.
Mm-hmm. Yeah.
So the beach that we're talking about that's been constructed is on the right-hand side of the photograph.
Correct.
Right?
Yep.
Okay. And then when you were highlighting the area in which the shoreline has been expanded or enlarged, you were specifically you referred to it generally, but specifically referred to an area to the left of these granite stairs. Am I right about that?
Correct. Yeah.
So in other words, they're different locations.
Yes.
Okay. I don't have anything else. Thank you.
Take final, Attorney Braun.
Yeah, just to come back to that final argument one more time, that alleged violation number 5. A clear reading of the ordinance indicates what we're talking about, right? Permanent piers, docks, wharves, bridges, boat launches, or other structures. It does not say anything about a shoreline. Again, shoreline to me speaks to something that would be more akin, as has been pointed out, to a beach, something that might have rocks as part of its nature, might be sandy as part of its nature. But what is described here in the explicit reference to shoreline itself does not constitute or meet any of the other indicators of that ordinance. And so again, that would be my argument against violation 5.
Just to put a finer point on it, the ordinance says, he didn't read it the whole thing. Permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line. Now, we heard Alex say that the DEP instruction is that this should be considered to be a structure. Now, even if that weren't the case, the ordinance also talks about a use extending over or below the normal high water line, which the shoreline is.
So,
I don't have anything else.
Chair, just to remind you of the sequence here. So at this point, I would turn it over to any of the other parties here represented by council, including Attorney Rachin, as well as members of the public to present, and then give the appellant one last final opportunity, as I think the appellant gets the last say here.
And I want to give Pete and Fred opportunity as well. Where does that fit into things?
Sure, yeah. Sorry, if they have any questions for, I guess, yeah, questions for the town, they should ask those now before you turn it over to the public.
Pete, Fred?
So, and one of the violations of the steps, we're talking about this, there was 2 steps there originally, but the second set of steps was modified correctly so that they added actually, it looks like concrete steps. So, I mean, the violation is because of there was no permit for that addition work to them. Steps are already there. Is that correct?
Violation number 3, correct, Fred?
I'm sorry?
Violation number 3, is that correct?
Yes, yes,
Yeah, and that was a question for the town.
yes.
I'm sorry, could you repeat your question, please?
Sure. In the first photo, or one of the photos you showed, there is 2 steps. And there's a violation of this. Is that violation because the second set of steps has been rebuilt, well, not rebuilt, but added to by, it looks like they've added cement steps to that. So there should have been a permit required for them to add them steps, or is it, or would be a whole set of steps are not legal?
Yeah, sure. I can address that. I'm going to share my screen. Okay, and so here in the top photograph, I think, and as Alex testified, there were some portable steps that were present on historically, and those weren't permitted just to begin with. But his testimony was that those stairs after are now placed and now have been extended, and so there's additional stairs appearing above those that are movable.
Mm-hmm.
And I guess let me ask Alex a factual clarification. Alex, in addition to that, these stairs that were movable, are they movable? Do you know if they're movable now, or if have they been moved to a different location, and have they been made permanent?
I'm not sure, but it really wouldn't require. The ordinance is pretty specific. You're allowed a single 4-foot wide set of stairs. There's no permit in the file for that second temporary or movable, permanent, whatever you want to call it, set of stairs. So they're not legal, and they've been expanded. So now you have an illegal, unpermitted expansion of an illegal set of stairs. So I don't find any way to make it legal, movable or not.
Do you have any further questions about that, sir?
No. I do have another question though on to where we're talking on the right hand side there, where the beach and no beach. And my understanding is the DEP gave them a violation on after they to the right, because they've added so much riprap there, that they got a violation for both the left and the right side, because of there was, I believe you said 400 feet of riprap added. Is that correct?
Yeah, so that in the DEP's notice of violation, that's what the DEP's, what it said. That's right, that they'd added 400 feet of riprap.
So DEP is also stating that it's a violation as well
Yeah,
as.
so right, that's right. The DEP found a violation and found that this was in excess of what would be permitted by a permit by rule, which allows for 100 feet, but they put in 400 feet. That's right.
Anything else, Fred?
No. No.
Pete, did you have any questions?
I don't have any questions, David. I just think that the information that has been provided clearly shows that there's been some violations here. I mean, the landscape is grotesquely changed.
We'll be sure to discuss what we see in this in a bit. I do have a question for Town. Just to confirm, you're withdrawing violation number 4 and violation number 11. Is that correct?
That is correct, Mr. Chairman.
Okay. And in regards to violation number 7 and violation number 8, it was indicated that Q-Team, you have stated that Q-Team states they did not do the work. Big Lake Marine is also stating they did not do the work. I mean, clearly the work was done, but what evidence do you have that Big Lake Marine did this work?
I mean, I think what we heard, well, I think we heard from Q-Team that they didn't do the work, and I think we heard them, maybe I may not remember this correctly, but I heard them say that Big Lake did this work. So, and Alex, do you have anything else you want to add here as to that?
Yeah,
that Big Lake did the work?
That's been what we were told through our conversations with Q-Team initially. They claimed that the excavation contractor was doing that removal. In addition to that, I do also have, going back to the slideshow, this photo showing Duran's equipment. It looks like there's a front loader. It looks like there is a excavator in there. So it looks as though it's pretty clear from what you can tell here. They're grading that entire section where there once was ground cover. I don't think we could get any more proof, who it was that actually came in and did that work. Q-Team typically does not remove anything smaller than a sapling. And that's at least what I took out of my conversation with Robert Fogg months ago.
And I guess what I'd also say is, I think we heard Attorney Braun say they trimmed the vegetation. So, we can talk about if trimming vegetation is removing vegetation. I think Attorney Braun would say it's different, and we would say trimming vegetation is removing it. So I think we heard from their attorney that they did it.
Do you want to speak to that, Attorney Braun?
Yeah, sure. So I would first point out that sapling would seem to constitute vegetation less than 3 feet in height as it relates to the matter in question. I also find it frustrating that the town would just take, despite the fact that they gave them notice of violations, would just take Q-Team on their face for any statements they made related to this, and that was in fact the basis of the dismissal as it related to violations 7 and 8 against them. And if all the town is presenting right now, which it sounds like it is, as it relates to evidence of who conducted this conduct, is that Q-Team told them they didn't do it, that seems, to be insufficient. We again reject the idea that we removed any vegetation that was less than 3 feet in height. We will continue to maintain that position, and we will continue to maintain that just generally violations 7 and 8 are duplicative of each other.
Thank you. So I'll start to open it up to the public. Attorney Rachel, do you have anything you'd like to share with us this evening?
Yes, nothing much more to add. I just did, as folks were speaking, I wanted to look at definitions. This is just simply with respect to Q team, the allegations about Q team. I think, I'm not going to revisit the evidence that was submitted in the last go round, but I think, we'll certainly state that, and I believe that Mr. Gosling's submission talked about how they only removed trees, and also, well, I don't know if that's somebody asking a question.
Yeah, somebody, it's Robert O'Neill. Robert O'Neill, are you able to mute?
I know. Come on.
Sandy, can you mute him?
Okay, Attorney Rachel, you're all set.
Okay, thanks. And also the definition of sapling, it's actually a defined term in the ordinance. And it talks about, I think there was some question about whether 3 feet or whatever, but it talks about saplings actually are species less than 2 inches in diameter at 4 1/2 feet above ground level. So anyway, I don't know how much evidence there was, if any, with respect to saplings. So I would submit that, the evidence, as you heard last time around, and I believe that there was agreement that evidence submitted in prior proceedings would become part of the record, that Q team's position, and there's no reason, I don't think, to doubt it, no contrary evidence has been submitted in this regard, is that all that Q team did was remove trees and not vegetation. And that's all I had to say. Thank you.
Thank you. I'll go ahead and open this up to public comment. Is anybody here tonight that's looking to speak in opposition? I forget the correct order. Let me change it. Speak in favor of this appeal. Is there anyone from the public tonight looking to speak in opposition to this appeal? Is there anyone from the public here tonight looking to take a neutral perspective to speak on this appeal? Okay, seeing here nothing, I will go ahead and close out public comments. Attorney Wagner, if you just want to sort of brief us on the next correct procedure.
Sure. So I advise we follow the same procedure that we have previously with our deliberations. So I suggest that the board go through issue by issue to identify the issues, identify what the violation is, what section of the statute that pertains to, and then what arguments have been made, and if they're sort of procedural arguments about like duplicative violations, we should address those, and then go through and let's discuss the factual findings to support the ultimate conclusions the board has. And as before, I'll take factual findings from a sort of consensus of the board, unless I sense that we're, veering, the board's veering in different directions, in which case we'll do a roll call vote, but I can just take a findings by consensus and then reach a tentative decision by vote as to whether to uphold or deny a violation, or to grant or deny the appeal based on a particular argument. And then after we go through that process, I'll consider all of those tentative findings and conclusions, and we'll continue the deliberations to the next date with instructions for me to prepare that decision. So with that process in mind, I suggest, because this is what I'm going to use to guide us here, that the board have before it the statement of findings of fact and conclusions of law dated today, August 30th, prepared by the town. In my opinion, I think that does a good job of framing out the issues, and I think we can use that as a guide for going through the factual findings. But additionally, I think the board should have before it the April 7 notice of appeal. And I also recommend having a copy of the prior decisions pertaining to 18 Fernwood so that the board can see its prior findings under different appeals concerning different parties, but similar, if not the same, factual allegations. So is everybody prepared with those materials and ready to move forward?
No, not in regards to previous findings. Although I would say to Pete and Fred, I don't want us to fall into, just because we did it a certain way last time, that requires us to do it the same way this time. I think we've been instructed that.
No, and just to be clear, when I'm, the parties, which I mean parties, I mean all the attorneys in the Zoom room here. In my opinion, we're under an agreement that evidence that was introduced in one hearing could be relied on in another hearing, and so references made to that in arguments. So I agree with you that in this appeal we should be making independent findings based on the facts here, but certainly you can rely on evidence from other hearings, and you can consider it relevant that in one hearing you found, there was shoreline cutting, and you can make that same finding here and say it's based on the same evidence and reasons of the prior appeal. But additionally, we find that cutting was done, by Big Lake Marine, or Big Lake Marine is responsible, for those who are not responsible. I think that's a new factual determination that you make here. So that's why I suggest having those decisions in front of you as well.
You have mine. Fred and Pete, do you have that available to you?
That was sent by an email, is that correct?
Yeah. Sandy sent us something on August 4th, 2022. It says notice of violation, decision management controls. She added to it, let's try it with attachment. You have it, Dylan?
I have two computers and I don't have it on the one that I'm on the side. I'm gonna try to find on this one.
How about you, Pete? Able to locate it?
Yeah, I've got one of the documents that Steve suggested, the one that has to do with the findings.
Wonderful.
So I think it sounds like we're ready to move forward. So as I see the first issue, and if the board wants to approach it in a different way, certainly let me know. But I guess I'd suggest that the first issue is this argument that I think addressed in the procedural section, but I think we can, since it was renewed in the substantive arguments, we should address it again. which is that it's a violation of the due process to rely on the presentations and findings made previously. And that is a ground for granting the appeal. So I think the board should address that argument first.
Fred?
Sorry. I'm just printing that. I got it on the other computer, so I'm printing it right now.
Okay. Pete, do you have thoughts on that?
Could you explain that again, please, so that I can, because I'm trying to look
Yeah,
at.
so the argument, as I understand it from Attorney Brown, is that the appeal should be granted and the violations vacated because there's been a violation of due process to essentially in that Big Lake Marine was not provided an adequate opportunity to challenge the evidence and assert its arguments in the prior appeals, and that those are essentially, in Attorney Brown's words, carbon copies, and so it's violated Big Lake Marine's due process rights because they didn't have an adequate opportunity to challenge those factual findings. Since that's really strictly a legal argument, I'll give you my opinion that I do think that they were provided an adequate opportunity to ask questions of witnesses, cross-examine witnesses, and Attorney Brown was present for all of that. Attorney Brown, in my opinion, was a party to the agreement that the parties could rely on evidence made in one proceeding in making arguments in future proceedings. So in my opinion, there's been no due process violation. So I would recommend that the board move to deny the appeal on the basis that there's been a procedural violation by treating the appeal separately.
Right, I would agree with that.
I would agree with that too.
You're muted, David.
Sorry, I got this crazy cough and I put myself on mute so I don't bother everybody. I guess I'm of the opinion tonight, Attorney Braun had opportunity to present their case just as other appellants did before. So, I'm in agreement that we should, forget how it's phrased, deny dismissing this.
It's a motion to deny the appeal based on the grounds that there was a violation of Big Lake Marine's due process rights by treating each of the notices of violation separately.
So this is a motion to deny it. So to vote in the affirmative would be to move forward.
Vote in the affirmative would be to support the town's position.
Okay. All right. Thank you. That was a little confusing now. So we need a motion. Well, we got a motion. So moved. Do I have a second?
I'll second that.
Any further discussion? All those in favor? David, yes.
Fred Miller, yes.
Lockwood, yes.
Okay. So the second issue, as I see it, is a larger procedural argument along the lines of what the prior management controls made, which is that there's a unnecessary duplication between allegations that certain conduct violated the shoreline zoning ordinance and a violation based on a failure to get a permit that would have allowed ostensibly that same conduct. So I think you can address that in a all at once of, should any of the violations be vacated on the basis that they are duplicative of other violations.
I mean, I'm looking at an estimate made from Big Lake Marine Construction to Management Controls Inc., of which it says Big Lake Marine will obtain all necessary permitting from the town and DEP. So, I mean, if I'm understanding you correctly, Attorney Wagner, and how you phrased it, Big Lake Marine indicated they would obtain the permits. So, and it appears they did not.
Right, but I guess as I see the argument that we should address is that certain violations are duplicative of others. So there's a requirement to get a permit, and that's one violation. But there's a requirement there's a violation of the shoreline cutting and a violation of the shoreline stabilization activities. And so, as you know, previously this board has dismissed that argument as the idea that they're duplicative. It did so based on, and you can certainly make reference back to your prior decision or tell me, for the same reasons that we denied it previously. I understand what that means, and I can pull those same arguments and findings into this decision. And basically, in summary, you concluded that these are separate conducts. There's the act of doing the cutting, and then there's the act of failing to get the permit, and it's valid to treat them differently. And you also made conclusions that it wouldn't be appropriate for you acknowledge that a court may do that differently in terms of assessing its penalties, but that's not a role for this board to get into. So I guess my question for the board is that do you still want to make those same findings and conclusions today as it pertains to this argument?
So I just want to be clear. I'm looking at the notice of violation, and just so I'm clear, violation 1 says filling in earth moving of more than 10 cubic yards. Violation 2 says violation and earth moving of more than 10 cubic yards without a permit. Is that what you're referring to?
Right. That'd be a great example.
Okay.
Being duplicative of one.
I personally am hesitant to blanket vote that because in previous discussions, there's at least one item where we had a board member present a case to not supporting that. So I would prefer to give the board an opportunity to discuss that again.
Okay. So I guess we could just go violation by violation then.
That would be my preference. Yeah.
Okay. Let's do that. So violation 1, that relates to the filling and earth moving occurring in violation of section 15U1. Which requires that activity be done in a way to prevent erosion and sedimentation of surface waters. So I would direct your attention to the proposed findings on, this is labeled as the first issue on the Statement of Findings of Fact and Conclusions of Law on page 6. And I would suggest to you that you go through those 1, 2, 3, 4, 5 proposed findings and consider whether you agree or disagree with those. If there's additional evidence that you want to highlight or additional findings that you would make to support or not support the ultimate conclusion that violation 1 should be upheld because Big Lake conducted filling and earth moving in violation of 15U1. Sorry, David, you're muted.
I am reviewing the findings of fact. What I find difficult is it's not clear which item in the findings of fact, as far as the document that we created for management controls. It's not clear. I would say item 1 correlates to item 1 for.
Yeah, it doesn't necessarily correlate that same way. So, again,
It just.
Yeah, what I suggest is we follow the notice of violation here which is 1, and in the proposed statement of facts and conclusions of law, we have finding first pertains to violation 1.
So you're referencing us to the document provided by the town? Is this
Yes.
correct? Okay, got it. Just bear with me here. So we're looking at number 1, filling and earth moving of more than 10 cubic yards. We're referring to shoreline zoning provisions, section 15, land use standards, erosion and sedimentation control, filling, grading, laguning, dredging, and earth moving and other land activities shall be conducted in such a manner as to prevent erosion and sedimentation of surface waters to the maximum extent practical. All activities which result in unstabilized soil conditions which require a permit shall be developed in accordance with an erosion and sedimentation control plan prepared in conformance with the requirements of Maine Erosion Control, the NPS, Bureau of Land and Water Quality, Maine Department of Environmental Protection, March 2003, and subsequent revisions thereof. I mean, given the information provided by the town, I mean, it's clear to me anyways that more than back and forth here. All right, too many windows up. So it's clear that more than 10 cubic yards have been moved. It's been indicated that there was not an erosion and sedimentation control plan. We saw photos indicating, that what erosion control was in place, was not sufficient in doing what it was supposed to do. Fred, Pete, please jump in.
I just want to make sure. So we're on the violation 1, is that correct?
Yes, filling and earth moving in more than 10 cubic yards.
Right.
Yep.
Yeah. And I think with what we saw with the pictures and what Alex explained to us, that there was definitely more than 10 cubic yards of disturbance or soil or the being moved, vegetation, all that stuff being moved. And spots of the riprap, the shoreline, you can see underneath it.
So accurate to say what I'm hearing is that the board agrees with all the proposed factual findings that are listed here. And that's also consistent with the factual findings that the board made. And this would be section 2 of the management controls decision.
I would say yes. Pete?
Yes.
Yes.
So in that case, I would suggest a motion to conclude as providing the notice of violation. Violation 1, Big Lake Marine conducted filling and earth moving in violation of Shoreline Zoning Ordinance 15 UE.
So moved. Do I have a second?
I'll second that.
All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
So that's a unanimous motion to uphold, make that conclusion, which effectively upholds violation 1. So same sort of analysis, moving on to violation 2. But also here we have the argument that violation 2, the failure to get a permit, is duplicative of violation 1. So I suggest we address that argument and then go through the analysis of looking at the proposed factual findings and our prior factual findings and make, again, the consensus on findings and an ultimate conclusion here as it pertains to violation 2.
I'm just looking up the table. So filling and earth moving of more than 10 cubic yards, in LRR1, LRR2, table indicates that a permit is required from the code enforcement officer. And a home permit was not obtained. And we've evidenced that more than 10 cubic yards was moved. So I believe this should be upheld.
I would agree.
Fred?
Well, I see on this, what it here on this number 2 here, I see it, that it says that we have to, that the filing of earth moving of more than 10 cubic yards, which, you know, we saw in the pictures, and it said has occurred in LR2 zone, and it's without a permit, and with Alex's testimony stated there was no permit issued. With the pictures that we've seen, I believe that that this was a violation.
Okay. If we have a consensus.
So I guess I would suggest then a motion based on these factual findings to uphold violation 2 because the board concludes Big Lake conducted filling and earth moving without a permit in violation of Shoreline Zoning Ordinance Section 14, Table of Uses, line 30.
So moved. Do I have a second?
Second that.
Further discussion? All those in favor? David, yes.
Camilla, yes.
Steve Lockwood, yes.
Okay. Actually, let me just confirm that you also would reach the conclusion that violation 2 should not be vacated on the basis that it is duplicative of violation 1, and you reach that conclusions for the same reasons you did in the management controls appeal.
I don't see it as duplicative, Fred or Pete.
I don't see it as duplicative either.
Okay, I think I have a clear consensus on that for preparing the opinion. So I think we can move to violation 3.
Number 3, illegal shoreline access. Second set of stairs to access water has been added without a permit. Shoreline zoning provisions, section 15, land use standards. Section B, principal and accessory structures. Number 8, notwithstanding the requirements stated above, stairways and or similar structures may be allowed with a permit from the code enforcement officer to provide shoreline access in areas of steep slopes or unstable soils, provided that the structure is limited to a maximum of 4 feet in width. The structure does not extend below or over the normal high water line of a water body or upland edge of a wetland unless permitted by the Department of Environmental Protection pursuant to Natural Resources Protection Act, Title 38, 480-C, and that the applicant demonstrates that no reasonable access alternative exists on the property. So I see per the town, shoreline zoning provides that stairways to provide shoreline access are only allowed with a permit from the code enforcement officer. A new stairway to provide access to the shoreline access was added without a permit. Our understanding is that the stairway was extended. There are what appears to be permanent steps in front of it. It was indicated that no permit had been applied for either in the past or currently. So I believe that this, for myself, I'm convinced of this one in the sense that it has been extended if it hadn't been extended, I think that for me could be a different type of a conversation to have in review of this. The fact that it was extended.
It appears that they've been, made from more of a movable set of stairs to, it looks like it's probably a permanent set of stairs where they're having concrete steps added to it. Again, in the beginning, I was not sure who put the original portable stairs there, but obviously it was moved, or by pictures showing that it had been moved to an extended set of stairs and appeared to look like it was more permanent. And without a permit, plus it was a second set of stairs, which only allows one set of stairs.
So to be clear, we're talking about both sets of stairs.
Yeah.
Pete, anything?
Yeah, I was thinking in the last picture that Attorney Wyckoff showed us of the shorefront there with the excavator clearly in front doing the work, that temporary set of stairs was not in the picture. So clearly it was moved, altered, and then as we saw in other pictures, extended into a more permanent set of stairs. So definitely did not exist before, in my opinion.
So would I say that we're in agreement that this should not be vacated?
Agreed.
So I guess I would characterize that as a motion to uphold violation 3 based on the consensus on the factual findings and the conclusion that Big Lake added a new stairway to access the shoreline without a permit in violation of Shoreline Zoning Ordinance Section 15B8.
So moved. Do I have a second? Any further discussion? All those in favor? David, yes.
Pete, yes.
Okay, number 4 was withdrawn by the town.
So the board could move to vacate notice violation 4 because it was withdrawn by the town.
So moved. Do I have a second? You're gonna have to move a little closer, but I can't quite hear what you're saying.
I'll second that.
Okay, thank you. So any further discussion? All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Yeah. So violation number 5. Piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland without a permit from the planning board, shoreline. This goes back to shoreline zoning provisions. Section 14, table of land uses, item number 17B, permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over and below the normal high water line or within a wetland require approval from the planning board within the RPSV, LRR1, and LRR2 districts. Well, it's clear the shoreline was extended. We do see it above the normal high water line. So the question is, do we look at it from the structure perspective, in which that's a retaining wall for those boulders at the end? Do we additionally look at it from a use as of shoreline? Pete, Fred?
Well, I think Attorney Walkoff said that, when he added that extra filing where it included the riprap and the rock area, it's extended, that was part of the violation. Lawyer Bruin was saying that there was no dock, pier, wharf, bridges, boat launches. He was saying that there was nothing like that there, but it's extended out to saying that it was the riprap that was put along the shoreline and extended it up. I think that would be a violation under that part of what the attorney says.
Yeah, I think the shoreline definitely went from a natural situation to something that had been filled in and changed, as you know, into more of a straight line, and rocks were definitely pulled out and to clear up the right-hand side of that beach area.
I am.
And just to be clear, we're, the board's finding that there was evidence to show that this was work performed by or in the direction of Big Lake. I think you're all saying that. I just want to make sure, because I didn't hear anybody say that explicitly.
I would agree.
Yes, I would agree as well. Yeah. Yeah. Based on estimate of land work, estimate of work to be accomplished, I would say yes.
So then I would suggest a motion based on those factual findings to uphold violation 5 because Big Lake expanded the shoreline without a permit in violation of Shoreline Zoning Ordinance Section 14, line 17B of the table of uses.
So moved.
I'll second that.
Further discussion? All those in favor? David, yes.
Miller, yes.
Lockwood, yes.
Okay. Violation 6. This is the allegation that Big Lake constructed a beach without a permit from DEP in violation of section 15O.
A beach has been constructed without a permit. Shoreline zoning provisions, section 15, land use ordinance, section O, beach construction. Beach construction on any great pond shall require a permit from the Department of Environmental Protection. Beach construction on any river and stream or brook capable of floating watercraft shall require approval from the Department of Environmental Protection. So our focus is on beach construction on any great pond shall require a permit from the Department of Environmental Protection. It's our understanding a permit was not received. It's also understanding that definition of a beach. And there is a picture that Alex showed during his presentation, which is not in the notice of violation, which does show a strip of area, which is sandy section, which to me is a beach. So I believe that a beach was constructed here.
Agree with that.
I agree.
And does the board agree there was no permit obtained for that work?
I've seen evidence of it.
Yeah.
So yes.
And what about the argument that you can't have it both ways in terms of a beach and an expansion of the shoreline? Are those duplicative or are those separate violations?
I believe those are separate because what was shown by Alex indicates a beach area, which was separate from the shoreline, which went specifically to the water.
So sensing a consensus there, I would suggest a motion that based on the factual findings articulated, the board moves to uphold violation 6 because Big Lake constructed a beach without a permit from the DEP in violation of the Shoreline Zoning Ordinance, Section 15O.
So moved.
I'll second that.
Any further discussion? All those in favor, David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. Violation 7.
Removal of vegetation less than 3 feet in height relates to shoreline zoning provisions, section 15, land use standards. Section Q, clearing or removal of vegetation activities other than timber harvesting. Further section C, in order to protect water quality and wildlife habitat. Existing vegetation under 3 feet in height and other ground cover, including leaf litter and forest stuff aware, shall not be cut, covered, or removed, except to provide for a footpath or other permitted uses as described in section 15Q, paragraphs 2 and 2A above. For number 7, the town has not shown to me that this is a violation, which Big Lake Marine has done. So I do not believe this one should be applied to them. But that's my 2 cents. Pete, Fred.
I mean, we all know it's been moved, but, you know, we don't know who moved it, right?
Correct. Q team indicates that it was Big Lake Marine. Big Lake Marine, I believe, is indicating it might be Q team. I don't know, but I should say they're indicating that they did not do it. So we have 2 parties indicating they didn't. Clearly, it was done, and but without any proof that Big Lake Marine is the actual ones that did this, I do not feel good about moving forward with this one. I feel it should be withdrawn or not upheld.
So
That's opinion.
just to read my notes here of the other evidence that's here. So I agree. You have a statement from Attorney Braun that Big Lake Marine denies being the one responsible for that, and I think they challenge the credibility of, or at least the idea that the board would just accept the credibility of Q Team's denial that it didn't. My recollection is then that the record would show that Q Team not only denied that it was responsible, but asserted it was Big Lake Marine. So I think that's on the record, and I think we also, I believe Alex testified to some machinery and took pictures of where it was located and how that could lead to the conclusion that it was Big Lake Marine that was responsible for the removal. So I agree with the chair's assessment that there's conflicting evidence, so it's up to the board to decide which evidence it finds more persuasive.
Pete, Fred, you do not have to agree with me. This is an open discussion.
Right. Yeah. No, I think I'm more inclined to think that this was Big Lake Marine. The pictures that we saw, the testimony that we've heard, they had the equipment in there to do the actual vegetation removal. And what we heard from Attorney Rachin was that Q Team came in and removed trees only. It's 2 different things in my mind.
Fred?
I mean, we know it's moved, you know, I mean, the pictures show that, you know, that the vegetation has definitely been removed. And there is definitely the excavator sitting there, you know, in the picture that appears that had been doing some work there.
I mean, I don't disagree, but there's not, to me, compelling evidence specifically that Big Lake Marine did this work. So. Any further discussion, guys? And then we'll go from there.
So just to keep with the way of phrasing the questions, I'll suggest a motion. based on the factual findings discussed by a majority of the board, it's just a motion to uphold violation 7 because Big Lake cleared and removed vegetation less than 3 feet in height from within 100 feet of the normal high water line for no valid purpose in violation of section 15QC. So do I have
I take exception to the word clearly.
okay. Did I say, I meant to say cleared or removed, not.
Okay, I may have misheard. So do we have a motion for that? Do we have a so moved? Brett or Pete?
So moved.
Do we have a second?
I'll second.
Any further discussion? All those in favor?
Fred Miller? Yes.
Pete Lockwood in favor.
All those opposed? David Murch.
Okay. 2-1. That is upheld. That's a majority of those present. Again, this is just preliminary findings, and I'll summarize this in a written opinion that we'll vote on at the next meeting. But the next issue here is violation 8.
Removal of vegetation less than 3 feet in height without a permit. Shoreline zoning provisions, section 14, table of land uses, number 5, clearing and removal of vegetation for activities other than timber harvesting. Again, it's clear that this occurred and occurred without a permit, but again, I don't see compelling evidence from the town that this was specifically Big Lake Marine.
What's the last part you just said, Dave?
I don't see compelling evidence that this was done by Big Lake Marine. I can't be convinced that they did this work.
I think what we're looking at here is whether there was a permit issued for whoever removed it or didn't remove it. Is that correct? It's definitely correct.
Well, there is, but I think there's the underlying belief that Big Lake construction, I get this all messed up. Say it wrong. Big Lake Marine Construction did the work. There's that underlying assumption. So, I mean, yes, I believe in brief, yes, I do believe that there was removal of vegetation less than 3 feet in height, and I believe this was done without a permit. So in regards to that aspect of this particular violation, I do believe this work was done. However, as it relates specifically to the appellant, I don't have compelling evidence from the town that they did this work.
So just to throw this out there for consideration by the board, I think you need to evaluate the question of what entity here had responsibility for obtaining permits, and what was there evidence, such as a contract, about who would have responsibility for obtaining permits?
That's a good point. So I do have for Big Lake Marine Construction on their letterhead an estimate to Management Controls LLC of work to be done. Project located 18 Fernwood Road, number 2318 Raymond, Maine, will consist of the following. And one of them is Big Lake Marine will obtain all necessary permitting from town and DEP. So in that regard,
I believe if you add, the equipment there in the same area with all that's been removed, I still think that's a violation.
I just see it as more than just the permit piece. It's the removal of vegetation without a permit. I agree, there's no permit, but removal of the vegetation. There's another piece to that for me, anyways. So I still don't think I can't put this one on Big Lake Marine. Fred, Pete, any further?
I'm going to maintain my previous position.
Same to me, I think it's a violation.
I think it's a violation.
Attorney Wagner?
Yeah, so I guess would it be accurate to check, at least by a majority of the board, that there's a conclusion that clearing was done, by Big Lake Marine, that there was a obligation to obtain a permit, and Big Lake Marine was responsible for obtaining all permits for all work and failed to do so. Therefore, that section 14 table at line 5 was violated by Big Lake Marine. Is that an accurate summary of at least a majority of the board's findings of fact?
Yes. Yes.
So based on those findings of fact, I would suggest a motion to uphold violation 1-8, right? Yeah, violation 8, because Big Lake Marine cleared or removed vegetation without a permit in violation of section 14, line 5 of the table of uses.
I make a motion to uphold violation 8.
Second.
Any further discussion? All those in favor?
Fred Miller, yes.
Pete Lockwood, yes.
Those opposed? David?
Okay. 2-1. So that's upheld based on a majority of the quorum present. So that brings us to violation 9.
Unpermitted shore stabilization, no permit. Shoreline zoning provision, section 15, land use standards for C. Piers, docks, wharves, bridges, and other structures or uses extending over and below the normal high water line of a water body or within a wetland. Subsection 12, vegetation may be removed in excess of the standards of 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. When necessary, the removal of trees and other vegetation to allow for construction equipment to access the stabilization site by land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access way must be restored. Revegetation must occur in accordance with section 15T. So it's indicated that this was a shoreline stabilization project. However, it was also indicated there was no permit obtained by the planning board. Which is what's required. Fred?
I believe that, especially with the pictures showing that, the equipment was right down in the water, right by the water working, and, it could get access from a barge. And that showed a picture of a barge next cove over. So, I mean, it was,
So this one, Pete, is Fred, we're looking at specifically violation 9. So unpermitted shoreline stabilization, no permits. The barge is violation 10. So looking at violation 9, unpermitted shoreline stabilization, no permit. In this case, permit has to be obtained by the planning board.
According to Alex, there was no permit issued by the town
Correct.
to do any of that.
So they.
I think there's sort of 3 factual issues here that you have to reach a conclusion on. Was the work performed based on the evidence that you've seen? Does that constitute a shoreline stabilization project? If it does, was it performed by Big Lake Marine? And if so, was it done without a permit?
So, in looking at that, it was indicated to Attorney Braun that this was a shoreline stabilization project. There's been other documentation, but I can't find it right off. There's evidence that, well, Duran excavating materials were there. And we know that there wasn't a permit. So I guess it kind of falls back to is Duran excavating. How do they relate to Big Lake Marine? Red Pete.
Again, the pictures tell us that there was vegetation there. It was definitely removed. There was equipment there that obviously moved it.
So to return to David's question briefly, not to interrupt that chain of thought, but in the relation between Big Lake Marine and Duran, I think that it's valid that the board should consider that, because if you're looking at evidence of, of something operated by Duran, how does that show that it was Big Lake Marine? I think the town's position is that these are all related entities controlled by the same person. So evidence of Duran doing something is evidence of Big Lake Marine.
I would agree with that.
I agree.
I disagree. Again, I recognize they're both have the same owner operator, but considering that town did two notice the violation, one to Durant, one to Big Lake Marine, indicates that they consider them as two separate entities. I see all right, hold on. So I'm reading Big Lake Marine Construction, and again, their estimate, an invoice for work to be done. Install 3 feet of riprap in a boat ramp area with 3/4 inch crushed rock, stone compacted. All cavities to be filled in with 3/4 inch stone at 45-degree angle. Replace fallen rocks around the deck area. All work to be completed by land and by barge as necessary to complete the project. Banking will be sloped as required, build up to 2.5 to 2 inches of the berm, bark mulch over the berm. So I would say, given I have to forget that I said that, because that was to whitetail. This one's for fernwood. 4 feet by 285 feet of erosion control measures as required by the DEP. Banking and sloping approximately 45 degrees. All cavities to be filled with 3/4 inch stone at 45-degree angle to prepare for installation of 6 by 12 riprap. Install approximately 2 feet by 285 fiber fat filter fabric and approximately 4 feet of bark mulch above the riprap. So I guess based on estimate of work, there is definitely some indication that they are going to be doing some work here with regards to the shoreline stabilization. So given that estimate of work and the signature on it, it's been accepted, would lead me to believe that Big Lake Marine did do some of this work.
So I'm hearing a consensus of the board on those factual findings, that there was shoreline stabilization, that it was done by Big Lake Marine, and that it was done without a permit in violation of 15C12.
Yes.
I would agree.
Okay, so can I suggest a motion that based on those factual findings, the board moves to uphold violation 9 because it contends it was a shorefront stabilization project without a permit in violation of 15C12.
So moved.
I second it.
All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, unanimous. 9 is upheld. That brings us to violation 10.
Sorry, my dogs wanted to say hello. All right. Violation number 10, unpermitted shoreline stabilization, no barge. Shoreline zoning provision, section 15, land use standards. Section C, piers, docks, wharves, bridges, and other structures and uses extending over or below the normal high water line of water body or within a wetland. Further, section 12, vegetation may be removed in excess of the standards in 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. So that's sort of the tough one, is we don't know if the planning board would have determined that a barge would have been feasible. However, no permit was obtained. The evidence was a barge for Duran Excavating, but the estimate from Big Lake Marine does indicate all work to be completed by land and by barge as necessary to complete the project. I would say, given Alex's feedback on how he viewed the situation, given that the estimate includes, signed estimate includes the condition for doing work by a barge, leads me to say that this should not be, this is applicable. Fred or Pete?
I believe it should, the violation should be upheld. The permit wasn't applied for. I mean, the equipment was shown there in place doing the work.
Yes, so you're clear, Fred and Pete, and you probably are, but when they showed us that picture of the barge, it's my understanding that was not a picture of a barge at
No.
that property, just evidence that they had a barge accessible through Duran Excavating.
Right.
I think that was shown to go to the, as relevant to the finding that it was feasible to use a barge.
That was my understanding as well.
Okay.
I agree.
So I'm sensing there's a consensus among the group that this was a shoreline stabilization project. It was completed from land without a barge, even though a barge was feasible under these conditions, and that work was done by Big Lake Marine, and it was done without a permit.
Yes.
So moved. Do we have a second?
So motion to uphold based on those factual findings. Conclusion that section 15C12 was violated.
And so do we need another motion? Another so moved?
Yeah, if you don't mind, just so it's
Okay. So moved. Do I have a second?
I'll second that.
Okay. And before we go to vote, I just want to confirm that this estimate does say all work to be completed by land and by barge as necessary. So they are indicating they would do that work. So anyways, all those in favor, David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
And finally, violation 11, unpermitted tree removal within 100 feet of Sebago Lake, that has been withdrawn. by town.
So a motion to vacate on the basis that it is withdrawn.
So moved.
Second that.
Any further discussion? All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
And violation 12. Oh, did I make that up? I made that up.
Okay, I can see it's what.
There's the argument that Big Leg's work did not meet the requirements for, or the argument that it would have been allowed under the permit by rule, and the town maintains that it did not meet the requirements of permit by rule. So I guess, does anybody think that the evidence showed that the town maintained the evidence showed that this did not qualify for a permit by rule? And I think they pointed to the DEP notice of violation. The board concluded, as a matter of fact, that based on that evidence, this would not qualify for a permit by rule.
Yes, I would agree with that.
Yeah, understood.
Yeah.
I read that violation notice, so yeah, I would definitely agree with that.
So I think another part of that argument by Big Lake Marine was also an assertion that all of the work complied with the shoreline zoning provisions. I think I would suggest to the board that based on all the factual findings, the board would conclude that Big Lake Marine did not comply with all of the provisions of the shoreline zoning or provisions based on the findings the board's already made. Is that accurate?
Yes.
Yeah.
Then I'd suggest a motion to deny the appeal based on the grounds that it qualified for a permit by rule or otherwise complied with the shoreline zoning ordinance provisions.
So moved.
Second that.
All those further discussion? All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
The only one I wanted to go back on was violations 7 and 8. I neglected to advise the board to consider the argument that they are duplicative. Does anybody want to revisit the motions to uphold 7 or 8 on the basis that they are duplicative?
No, I don't believe them to be duplicative.
Okay, and the reasons for that, can I say that they're the same as how the board treated that issue when it was raised by management controls?
Yeah, but it also falls back to violations 1 and 2.
Okay, same reasoning there.
Yep.
Okay, so I think we've addressed all the issues as I see it on this, and I've got clear preliminary findings of fact and conclusions of law here. So I would suggest that the board make a motion to instruct me to prepare a draft decision reflecting that, and then also move to continue these deliberations to the next scheduled meeting.
So moved.
Second that.
Further discussion? All those in favor? David, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, so Mr. Chair, turn it back to you. My understanding is that is all the old business that all the parties have agreed to address today.
That would be my understanding as well.
Yeah.
So, and we took, we took everything off the table. So the ratification of findings of fact, that's actually completed. So all the public hearings, Duran Excavation, that's been completed, as well as Duran Excavating, 28 Whitetail, so 18 Fernwood, 28 Whitetail Lane have both been completed. So I will entertain a motion to table the administrative appeal, re-notice of violation 310-2022 for Gregory P. Vaughn on behalf of Big Lake Marine, and administrative appeal, re-notice of violation issued 128-2022, B.B. Ratchet Esquire on behalf of Management Controls for 28 Whitetail Lane. And then finally, administrative appeal, re-notice of violation issued 310-2022, applicant Gregory P. Braun, on behalf of Big Lake Marine for 28 Whitetail Lane. Motion to table all those for the next meeting. Brad B.
Yeah.
You need a snow move.
Yeah, I need a so moved, and I need a second.
So move.
Second.
All right, all those in favor of tabling, David, yes.
Brindle, yes.
P. Lockwood, yes.
Very good. So, attorneys, I thank you for your time. Our next meeting is scheduled for September 26th, I believe anyways, Monday, September 26th at 6 p.m. Again, via Zoom. Pick up pretty much where we left off. Does that match everybody's expectations? So,
Yes.
all right, thank you much. Mr. Wilson, we also have on our agenda new business administrative appeal, re-denied business license. We have bylaws in place, Mr. Wilson, which require us to not take on any additional business after 10 p.m. So unfortunately, we're going to have to table this until our next meeting, and hopefully we'll have time to get to it then. So if not, there is another meeting on the 27th. So we have a meeting on the 26th and then a meeting on the 27th.
And those are both in September, right back to back on Monday and Tuesday.
Correct. Yep.
Great.
Yeah, we're just working to try and get all these outstanding old businesses.
I'll be back on the 26th at 7.
It's well, yeah, I guess that's 6, but it starts at 6, but I doubt we will get to that before 7. So,
Well, have a good month, everyone.
thank you.
Thank you.
So, because we're not going to take on any new stuff, I'm going to go ahead and skip code enforcement officer communications, and I just need a motion for adjournment.
Motion for adjournment.
Second.
All right, all those in favor, David, yes.
Brindle, yes.
P. Lockwood, yes.
All right, thank you, everyone. I appreciate your time.
Good
Thank
night.
you, David.
Yeah.
All right,
Good night.
bye-bye.
Good night.